Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Welcome in. It is Monday. Sorry, I don't know why am I so tiny. Oh no, not like that. Sorry, it's not been a good morning. I got a little bit behind getting ready and everything. I don't know why I cannot go bigger. Good morning, everybody. Um. I am all first day back at work, and I am all confused. I haven't set up half of the things. Enjoy lurking, Denise. Oh, you know what? I was saying your name, and then I was trying to open the dashboard for the original Nightbot, and I I was typing your name instead of Nightbot of I can't even I don't even know what I'm saying anymore. But we are here. It's the beginning of another great week. I went back to work today, and I'm telling you, I was not ready for that. I I don't know what I did, but my cameras are swapped, so I don't know how to make myself bigger in your screen. But I think the size that I am right now, I think it is fine for now, and I think we'll stay like that for today. Just trying to finishing off setting up things that I did not do half of the things that I was supposed to do before I came on stream because I was a little bit late. I did not know what to wear today. I was trying to decide which hoodie I was gonna wear, and Nightbot was is as did half of the washing, and most of our hoodies are there right now, and so I had to kind of reuse another one. So all my days, I was not ready to go back to work. Waking up at 4 o'clock in the morning, I forgot how hard that is. To go back to work and wake up at 4 a.m., do my shift, having to come back home, and then like doing my investigations, doing a bit of like work and everything for the stream. I forgot how hard that is. I mean, it is. It last week was an awesome week, being able to just chill, watch court all day, and just be enjoying that. And now this week, going back to reality, that was hard. So we are waiting for the day to start for the Collin Griffith trial. We are on day 4 of the trial. We have 25 objections by my count on the counter, and today is day 4. What am I expecting today? At least my opinion, right? Let me know if I'm wrong. Um, in the chat below. But before I do start saying what I believe, I just want to give a shout out, and I will later on again when she does come in, because I don't know if she's in already. But I wanted to take to thank Ivamos that on Saturday at the end of our live stream, she gifted yet again 5 memberships to our channel, and I appreciate everyone that has continued supporting the channel. You can just by watching, just by pressing the like button, you're already supporting a lot. But I really appreciate every single one of you. But big thank you to I for her continued support as well to the channel. Um, like I was saying, hey, good morning, Susan. Welcome in. The court is about to start. I think I'm hoping, because hell yeah, I was playing a game right before I decided to get ready for the stream. I was playing a video game, and I got a notification saying, "Oh, Law and Crime was gonna go live," and I was like, "Huh? What is already?" So, but no, it was like in live in 30 minutes. So. Happy Monday, Susan. Happy Monday, everybody. Hello, Lois. Hello, Denise. Hello, Kay. Everybody that is in chat. Nightbot will be here shortly. He's just finishing up getting ready for the day, even though it's almost 2 o'clock over here. But it is okay. He deserves it a late day. He does work a lot. Like I was saying, morning. We are on day 4 of the Collin Griffith trial. He is accused of unaliving his mom, but he does say that it was self-defense, that she fell on the stabby, and perforated her neck, which I don't believe at all. But what's going to happen today? So today, oh, talking about that, the feed is come live. Let me just set that up so we can have that and be ready for when court starts. So what does that mean? It means that there's a possibility that the state might rest today. I don't know 100% for sure. Don't quote me on that. I need to. Oh, there is noise coming from court, but I don't think they are gonna start just yet. Sorry, I'm just adjusting myself on the screen. I think that looks fine. That looks perfect. All right. Um, we are just waiting, and as soon as it starts, I will be quiet. So, state might rest today. We might have a very quick defense presentation. I think they are testing the mics. I will turn that off. Don't worry. When they do come back, I will put that on back on. But the defense might rest. The state might rest today. We might hear stuff from the defense, and also they might rest today as well. The defense, because, and I'm saying that's my speculation, because on the court system they only have court today and tomorrow. They don't have anything else. So there is a possibility that probably tomorrow we will be on verdict watch for this trial, which would be perfect because our new trial, the jury is being picked today out of Tennessee. So that would be amazing. So if we have to catch up, we'll catch up. Not a problem. It's going to be okay. And obviously, we'll do the same thing as we did with Natalie. If the verdict comes through halfway through the catching up of the other trial, we'll pause, go back, finish off Collin in the trial of Collin, not Collin himself. Don't sue me, please. Don't arrest me. I'm fine. And we'll do that again, and then we'll carry on with the Megan Boswell case because I am not expecting the jury to be picked this today in that case because it was such a high profile case. It was just a massive case that picking a 12 juror in Tennessee for that case, I don't think it's gonna take more than a day. That's my opinion. At least that's what I think. Don't quote me. If they don't take and we have to catch up more, we have to catch up more. It's fine. We'll be okay. We'll catch up. But that's our next trial. We've been very fortunate. We've been having trials back to back, which is amazing. I am very glad. But sadly, I haven't had the opportunity to do a research stream on Megan. So we all gonna go, like, I know a bit more. I've done the timeline. It's ready and available if you want. It's on Linktree, on my Linktree. I'll put the link in the chat if you want. The timeline for the new case, it is there. It should work, the link, in a second. And it is available there. If you want me to send you by email, I can send you. Just let me know and I will do that, no problem. But the research stream, we might not have a possibility to do it. So on Saturday, we might be talking about a case, a UK case. We're going to go back to probably. Oh, hello, Nightbot. Welcome in. Good morning. There's more than 3 people here, the Nightbot. It's a great group. It's a small group. I love it. So, like I was saying, on Saturday we might be doing an actually quite good case that is happening right here. Well, in the UK, for out of it, this one is from Northern Ireland, but it is for the defendant is English. So no, sadly not. It's not that case. It's another case. It's a new case. The case that I saw in person, Kate's done and over with. He's serving his sentence and is in prison and is living his worst life. I don't know. But this is another one, and it's actually quite high profile. Just to give you a bit of a taste, this guy was a YouTuber, right? He had a girlfriend. I don't know what happened, but either they broke up or they were about to breaking up, but the YouTuber unalived her. But the way that it did, it was so I don't know if I should say smart or scary, that he pretended that he was on a live stream, right? It was a YouTuber. He used to, I think it was video games that he used to do. I don't know, I need to do a bit more investigation, but that's the like storyline. That so he was a YouTuber. He faked a 6 hour live stream, right? And to create an alibi, and then he went and alived the girlfriend and almost got away with it. So it's just an interesting case. First of all, how can you fake a life? I don't know, because well, in court we can't, because you guys wouldn't be able to ask like that, tell me that I was faking. But it's just like very interesting. There is very various clips out of the live stream that are on the world of YouTube that I'm gonna include on the live stream that we're gonna do about that case. But it's just a very intriguing case, and I really got my attention this weekend. And I was like, I need to talk about this. This needs to be, spoken about. But the good thing that I was checking the other day, right, is that Northern Ireland, because it's part of it's not part. I don't want to be incorrect corrected by Nightbot, but they live stream their cases, not as England, that they don't live stream the cases and only live stream the sentencings. In Northern Ireland, that's a possibility of them live stream the whole case. So what I was about like gonna do is, I'm interested in going live to actually see it live, but also live stream it on here on this channel. But we would have to do it a bit different because of the time difference. Oh, nice. That's I don't, is that to Northern Ireland? I don't know if it is, but because I want to go live. I wanted to go and watch it live. Probably like the media and the public interest on this case is going to be a massive one, because he was actually a quite famous YouTuber. So, and he's not out on bail, because the judge was saying, I mean, he faked a live stream. It was it's absolutely interesting. And the thing that he was saying, oh my, so sorry, I can still hear court. So I on my headphones, and someone literally just blew his or her nose on the mic, and it's just gone into my ears. So but it's just interesting that this fact that the judge said that he's not going to give him bail because of the influence that he could have had on the witnesses, and also because of the way that he faked the live stream. He's so like a genius type person that like they did not trust him with bail. So it's just very interesting. um Oh, I am. I'm gonna have a yogurt out of the Atlas. Like, thank you very much. And now they went silent. Now they muted the mics. Really? After you, it's Monday, y'all. But so that's gonna be a case. We'll see how it happens, because if I have to go, if I want to go to another island, Nightbot will have to come with me, but I need to figure it out. But then that's the thing. If I'm streaming that case, I might we might well, we'll be playing catch up, because if I start live stream at my normal time in the morning, you guys will be asleep and you guys won't be able to sleep. So we probably just watch the same time as normal court. We start about 9 a.m. Eastern, and then go from there, and then watch it the of that day together. But we'll see what happens. I did try to call the court today, but I did was at lunchtime, so I need to call as soon as I get home from work. I need to call them tomorrow to see if they have any information. Because if we do can live stream, I need to start organizing things to see if I'm going or not, or if I'm just staying, and then we're gonna catch up. But that would be very interesting to follow, and I think that would be a great thing for us, for the channel, and it's going to be good for following a UK case for once, and see that side of the UK system. Because the other day, when we finished watching the Natalie Cochrane case on Saturday, we finished the case, we put the bow, we put her in the drawer. One last thing, you know that the jurors, right? The judge said that the jurors were going to carry on jury duty for a bit more. So they are gonna carry on with another case or anything. You guys know when I went to court last week again, sorry again someone, when I went to court last week and I told you about that mini trial or the end of the trial that I caught in the morning and they came with the verdict in the afternoon. If you don't know what I'm talking about, I did a whole video on my channel about it, my day in court. Just go check it out after the stream and then you gonna understand what I'm saying. So the same thing as the Western Virginia in the UK, well, at least in this court, the jury finished that case and they moved on to another one because the judge of that day, she said that you are released from this case, you can talk about this case but not about your jury duty because you're going to carry on. So that was very interesting that West Virginia and the UK, at least this court, did the same thing, that the jury it's not released after the end of the case, which is rather interesting. um Sorry, there's people in court and like they're talking and there's like it's nothing spicy, don't worry, because if it was something spicy, I got you. Oh, judge is on the bench already, we only 2 minutes late. Nice. Oh, they have a sprinkler system, which is very good, it's very handy. But yeah, so that was very nice to see that they are very similar in West Virginia and the UK, not like the other states that like when you're done with the jury and you move on. Oh, I forgot to put the counter. Where's the oh, where did I put the counter? Oh no, I've lost it. I know it's on the screen, but I lost the window that there we go, found it. I need that one handy because if we have an objection, I need to be quick and do it. See, I told you I did not sort myself out this morning when I went live, and I went live late, like a minute or so late for the first time ever. So I'm not always early, Lois. No, I'm joking. Court is about to start. I mean, I'm hoping, and I can wait, I can stop talking, and you guys. Oh, I didn't even do my drink. I'm gonna have to ask Nightbot to go and do my drink for after me. But anyway, how was your guys' weekend? How was your Sunday? Yesterday, as if you were a member, I did a members video. Now Sundays is gonna be sorry, 1 second. Sundays, I have institute the Sundays is gonna be members days. So every Sunday I'm gonna do a members video. My idea is Judge might come back. Hang on, I'm gonna put the sound of the court.
Yes.
Well, we still can't hear the judge, but we can hear chicken lips.
Yes.
Oh, hang on 1 second.
And actually, Mr. Hendry will be making the arguments.
We're going to do it now. Sorry, I was setting my computer under.
Judge's mic is very, very low. We can't still hear him properly, but we can't hear the defense. Apparently, state is resting today. And then Henry is going to do.
Defense moves for a judgment of acquittal on both counts. I will work.
All right. State is rested, guys.
First. The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap. And typically, the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe Kathy Griffith as angry. They describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Collin and as she approached Collin, and even up until she was so close that Collin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Collin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Collin dragged her into the house, the actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point, we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Collin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery. When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Collin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that in this case, Your Honor. We have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched at that time, that she said that you're hurting me. We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with. So we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or was in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Miss Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge. As far as the first-degree murder goes, Your Honor, The evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Walantis's testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me again, if anything, then. Premeditation does not override someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Collin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there is just a waiver of self-defense, if this was a fight that got out of control, I apologize. Do you have to?
Just my child's school keeps calling. I'm wondering if there's no emergency.
Yes, Your Honor. I understand.
Judge's mic is off, so if you guys have like a break or something, that's when the judge has to talk. But I don't know what he's just said because I can't hear what the judge is saying because I think his mic is off. I think he asked to step out. I don't know. He said something that now we are off the record. So what's happening right now is, for everybody coming in, is state has arrested. They literally came in saying we arrest, and now we're having a JOA, a judgment of acquittal. So basically the defense is saying to the court on the record that the state hasn't proved that Collin did what he did, that the kidnapping charge did not happen, that Catherine went in voluntarily by her hair into the house. That's what they're saying. And then now they are going over the unaliving charge. I don't know if it finished or not, is JOA, but the court now is on a recess. I don't know what's happening. We'll see what happens. And they are coming back now. So we'll just check it out and we'll see if state defense has a case.
Okay. Your Honor, I was speaking as to the if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged, that this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered because I don't believe that the kidnapping is sufficient to reach that. And there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injuries showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house and it's unclear what happened. We have no evidence. We have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside. This fight escalated, that there was at some point, someone gets a knife and then Miss Griffith ends up dead. And to me, that is the realm of a second-degree murder. That is a standard fight that goes too far, and that is what the jury should be considering. They have not had any proof, again, that would rise to the level of premeditation. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue. But again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping and it should not be under the felony murder statute, and it should only be a second-degree murder.
Your Honor, as it pertains to the kidnapping, from two independent witnesses, we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, stop, Collin, you're hurting me. At which point the defender dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her. When he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and in the head. And when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that it in fact was a murder, that it was not self-defense, and that he had planned it, the defendant's anger level was through the roof. So once he gets her inside, he has no prying eyes, he has no witnesses, and he can inflict anything and everything he wants to on his mom. So once she gets yanked from outside to inside, and mind you, he had her by the hair, which there's no way she could get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or to terrorize her, and or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continuing on with the premeditation, and then stab her, not just any place, not just cut her, but stab her and one of the most vulnerable parts in the human body, which was right in the neck. And as we heard from Robert Willantis, the defendant accomplished exactly what he wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So, Judge, I would rely upon the facts of the evidence and the whole record and ask that you deny the defense's motion and allow the jury to consider both the kidnapping charge as well as the first-degree murder charge as we go forward, Your Honor.
Your Honor, as to some of the arguments just made, first off, there's been no evidence of anger in the moment on the part of Mr. Griffith. We have the evidence from the neighbor that he was calm, that Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise. Like he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Miss Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, it's being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight, we have that. We don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him, and they can tell that he's much smaller than me. And I'll tell you, I'm not 6'2". So I don't think that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car. We have her intent. Yeah. And she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside. So we have her not wanting to be pulled by the hair. But again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that has been shown. So she said, "You're hurting me," loudly enough to be heard. That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery, and then a fight that happened inside, and that fight led to a death.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense, and the motion is denied. Is there anything else we need to discuss before we bring the jury?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular you
No.
wanted to address now?
No,
Are we ready for the jury?
I believe so.
Sorry, if you guys did not hear that, the JOA was denied yet again. I don't know what's wrong with the judge's mic. I don't know if he turned it on or not, or no one has reminded him, but I will try my best to boost the audio when he's speaking. But he said basically that the state has proven some of the facts and it is going to leave up to a jury. Basically, I'm not paraphrasing, that is going to leave up to the jury to decide that in terms of the charges. I'm wondering if there's any lesser included. Normally he was saying chicken lips asked for when they do the jury charge, and the judge said when both rests. So and then he asked if she was looking for something specific, but basically, so we'll see what case do they put. At least a couple of witnesses, they do have it. How I haven't opened the document with the witness lists. I need to do that. At least some witnesses we are going to have from Colin's side. The grandma is going to be one of them. And then we'll actually see if he testifies or not. I particularly want him to testify. I want to hear his side of things because, I mean, we can't hear from Kathy's side of things, sadly. So we'll see what happens there, and if we can listen from his side. But at least the grandma, Susan Deathman, we're gonna listen because the state is done with their case. I can delete that thing, those things. I have a few people on their side of attorneys, but it might be just today and a bit tomorrow, and the jury's coming in. And I'm sorry, guys. No, I haven't fixed the soundboard yet. It is on a list to do. My list keeps growing and growing, and little by little, we'll get there eventually. On fixing things on our stream. So, but I see Denise's sides of views that is still on the fence, but it's just too. How can in the space of a year you have so many reasons to unalive both of your parents? And yeah, that's my thought, Denise. He's claiming self-defense, and that's what I've been saying, that he's gonna just like, oh, here we go.
Thank you again for your service in this case. Mr. Levine,
Your Honor, the state rests.
the state having rested its case, what says the defense?
The defense calls Susan Detman to the stand.
This way, man.
Sorry.
Step right here, raise your right hand, be sworn by the clerk.
Thank you.
This way.
Ms. Detman, will you please introduce yourself to the jury and spell both your first and last name?
Susan Detman. Susan is S-U-S-A-N, and Detman is D-E-T-H-M-A-N.
Ms. Detman, how are you related to Collin Griffith?
I'm his maternal grandmother.
So your daughter was Kathy Griffith?
Yes, ma'am.
Griffith, sorry.
Yes, ma'am.
Okay. So give the jury a little bit of an idea of who the other members of your family are. Who was Kathy's father?
Robert Willantis.
Were you married at some point to Robert Willantis?
Yes, we were married for 19 years.
When did you divorce?
We divorced in 1998.
After you divorced Robert Willantis, did you get remarried?
Yes, I did.
Who did you get remarried to?
Inaki Markovich.
And might need to spell that last name for the court report.
M-A-R-K-E-V-I-T-C-H.
Ms. Detman, who are your children from your marriage to Robert Willantis?
John Paul Willantis, Kathy Willantis Griffith, and Christy Wolantis grooming.
Did you list them in ascending order of age, youngest to oldest?
The youngest to oldest.
Okay. Do you have another child?
Yes, I do.
Who is that?
Kevin Markovich.
And that's from your marriage to Mr. Markovich?
Yes.
Now, Kathy, obviously Collin was Kathy's son. Did she have any other children?
Yes, she had an older son. He's still alive, Christopher Ray Griffith.
How old is he?
He is 24.
I want to ask you a few questions about Robert Wolantis, your ex-husband. When you divorced in 1998, who got custody of your 3 children with him?
I did.
And since 1998, has Robert Wolantis been a big part of your life?
No, except for the custody battles we went through.
What about, are you aware of his relationship with any of the 3 children that you had with him?
He didn't have a relationship once he was not granted custody of John Paul. He didn't want Kathy, considered Kathy to be damaged goods. He only sued for John Paul.
Okay, but what was his relationship like with his children after the divorce?
He didn't have a relationship at all until Kathy divorced and she reached out to her dad.
When did Kathy divorce her husband and the father of Collin and Christopher?
2019, if I remember correctly. It was like December of 2019 when they filed. And I think it took a couple months for the divorce to actually take place.
Okay. Now, we saw pictures of Robert Wolantis on a trip with Kathy.
Yes.
Tell the jury about that trip, what you know about it.
So Kathy wanted to meet the biological Robert's mother, the biological grandmother, because Kathy had many medical problems. So she asked me, she said, Dad said he'll take me to California to meet his mom. They lived in Anaheim. The mom lived in Anaheim, California, but you'll have to pay for it. And I said, okay. I said, just please try not to do anything too expensive. And I'll see what points I can use for the hotels. And fly over there. You guys don't need to rent a car. You can use your dad's car if it can make it to California. If not, then we'll get a rental car.
So, Ms. Stepman, did you in fact pay for Kathy to go on this trip with Robert Wolantis?
Yes. I paid for all the food, all the hotels, Disneyland, all of that.
And when was that trip?
That was before she got Collin back.
So before 2023,
Yes.
after 2019 though.
And after COVID was over with.
Okay.
So I believe it was 2022.
Are you aware of any other trips like that that Robert took with his other 2 children?
No, he didn't really have communication with them.
All right. So I want to ask about Kathy's funeral or celebration of life. Did the family hold such a thing for Kathy?
Yes, we had a celebration of life right here at the funeral home in Lakeland.
Was she actually buried or was she cremated?
No, she was cremated. She had conveyed to me as well as to her sister and brothers that she never wanted to be put in the ground. She wanted to be cremated and later taken back to the ocean in Key Largo and her ashes be put at the Jesus statue that we have under the water in Key Largo.
Has that been done?
No, we're going to do that this summer.
Where are Kathy's ashes right now?
Right now, they're at Christie's house.
Was Robert Willantis invited to the celebration of life?
No, he was not.
Why not?
Robert tends to be very disruptive. He has difficulty with truthful manners, and we just did not want to have more lies and disruption. The final time that we could say goodbye to Kathy.
I'm going to ask you some questions now that may also be difficult. In the last roughly 2 months before Kathy died, what personal medical things were you going through?
So in the last part of June, I was diagnosed with stage 3 colon cancer. I had to have part of my colon removed and an ostomy put in place.
After you were diagnosed and had your surgery, did you have a fight with Kathy over Robert Willantis?
Yes, I did. Kathy was very adamant that she wanted Robert to take care of me, that I needed to pay for his flight from New Mexico to Lakeland, get a hotel for him for 2 weeks, and get some sort of a car, and even pay for his food. And I told Kathy, I said, that's ridiculous. He hates me. I don't want to be hurt by him. Plus, has lost his nursing license. I want a real nurse that has.
Okay, hold on.
I'm going to just object to all this collateral accusations. Sustained.
Ms. Stepman, as a result of you not wanting to follow Kathy's wishes as far as Robert Willantis coming here and taking care of you, did that cause a break in communication between you and Kathy?
Yes, she refused to talk to me. She blocked my phone. She told me if I came over to the house, she would have me arrested for trespassing. She said, you can contact Collin, but you can't contact me.
And that, okay, I'll move on from this. Mr. Willantis on the stand mentioned that Kathy got Collin a second phone, and that must have been what Collin used to talk with Mr. Willantis on the phone every week or every other week. Tell the jury what you know about a second phone.
The second phone, I purchased a second phone when Collin came to live with me in the January, February time period, the first time she threw him out. And I couldn't leave a kid in the double wide by himself without a phone. Plus, since I didn't
Well, hold on. Why didn't Collin have a phone with him when he went to live with you in January of 2024?
Because Collin and I were at the Mexican restaurant in Port Charlotte. Kathy and Collin and I were supposed to go. When I got there, Kathy said, no, I don't want to go. And I said, come on, at least have some nachos or something. No, I don't want to go. And I said, can I take Collin with me? Sure. So while we were at the Mexican restaurant, she called me and she said, don't bring Collin back. I never want to see you or Collin again.
And the phone that Collin had at that point, where was it?
It was at Kathy's house.
Okay, so you brought Collin to
the double wide in Arvindale, and I didn't even have internet because, of course, I wasn't there all the time. So if I needed to, I'd hotspot my computer. I didn't want an extra expense for internet or cable or any of that. And so I realized I couldn't leave Collin here without a phone. So I told him, I said, we're going to have to go to AT&T and get a phone for you. And I even got a 786 area code because that's the area code that I have in the Keys.
And that second phone, did Collin have possession of it from January of 2024 all the way up until September of 2024?
No. He only had possession of it for that small amount of time from when he came to, which would have been, it was either the end of January, the beginning of February. He had possession of it there. And then when he left, he took it, and I immediately got it by that weekend.
Okay, I'm actually going to show you what's been marked as defense exhibit number 16 and see if you recognize it.
Sorry, court has gone really quiet. I can't hear a thing myself. So we'll just see. It's just very odd. I have tried to tweet someone, Kathy Russo from Law and Crime, to see if they can do anything, if they can talk to the court themselves about the audio there, because we can't hear the witness or the judge. So, yeah, that's what he's saying, Susan. Yes, that he fell on the knife. But what the ME said was that the knife, the wound that she had on the neck was way too wide and way too deep to be self-defense, and she falling from on the knife, and it would be very hard to fall on the knife that was standing up. The knife had like a bottom, because the knife had to fall on the knife to cover on the neck.
According
What?
to this,
No, okay, don't leave it.
Why
Do you
did
recognize those
have to fall on the
messages,
knife?
between you and Kathy?
Do that.
No.
So he's claiming self-defense. So it's just a bit weird. And I think he's gonna have to testify. There's no way he's gonna go away with it.
Do you remember there being a period in January of 2024 where where Collin was with you for several weeks and Kathy didn't remember that he had gone with you?
yes,
And do you know what was going on with Kathy at that time?
she was suicidal, taking pills. She just didn't want to have her life. She was drinking
Okay.
excessively. She drank Everclear as her alcohol of choice.
Okay, Ms. Stepman, just answer the questions, okay?
Yes.
You mentioned that she was suicidal in January. I'm going to show you what's been marked as Defense Exhibit 15. See if you recognize the subject matter of those texts.
Yes.
Judge would like to admit Defense Exhibit number 15 into evidence.
Any objection?
No objection, Judge.
And received.
Ms. Stepman, Defense Exhibit 16 stated February 5th of 2024, and the blue text at the top was Kathy's number 941-258-0963,
Yes.
and were you the number below that?
Yes, ma'am.
And you mentioned the 786 number, but you had two phones, correct?
Yes.
Why did you have two phones?
I use one for work and one for personal.
So The blue message on top talks about Kathy just having been released from the ER for an accidental overdose. Was that one of the times that she had had a suicide attempt?
Yes.
So the phone that you bought for Collin in either January or February of 2024, and I'm sorry if you already answered this, but he didn't keep that after the brief period that he lived with you then, did he?
He went home with it and I had it back on the weekend.
Okay, so shortly after he went back home to Kathy.
Yes.
So Kathy, it sounds like off and on had estrangement from various family members.
Yes.
You mentioned that you and she didn't speak for quite some time after your cancer diagnosis. Had she cut other members of the family off at other times in her life?
Her and John Paul were not speaking.
Do you know why?
Yes. She got mad at his wife because the house wasn't clean to her standard. And she said, I'm going to call DHS, which in our state is Child Protective Services, that Isabella was not taken care of, that she was in danger, something. I know DHS ended coming up to John Melontes' house. Of course, the investigation proved that there wasn't a problem. And John just said, I will never have anything to do with her again. She crossed the line.
Any other family estrangements from Kathy besides you and her brother John?
So Kevin and Kathy were supposed to go to Washington, D.C. together.
Kevin is your son with
Yes, and Kevin
Inaki.
and Kathy were pretty close. They were supposed to go to Washington, D.C. together because Kevin was in officer basic training in Virginia for the Florida National Guard. He just graduated from college, and he had time off during the 4th of July. And Kathy said, it'd be great if Collin and I could meet up with Jean Paul in Washington, D.C.
Do you mean Kevin or?
Kevin, I'm sorry, Kevin would meet up. I was supposed to go because, of course, my cancer, I
Okay.
couldn't.
Miss Valentis, I'm sorry. I know you're nervous, but the estrangement, how
Yes.
that
So what
occurred.
happened is Kathy contacted Kevin and said, unless you help me get your father arrested, meaning Inaki Markovich, I don't want you coming to Washington, D.C. with me.
Do you know what Kathy was referring to as far as helping her get your husband arrested?
Yes, they had had an altercation in our farm in Arcadia during COVID. So it was during 2020, around Easter time. It was before Easter. She threatened him with a baseball bat. And she said she was going to get her gun and shoot him. And my husband brought a shotgun out and said, I have a shotgun here. We're not going to be doing this. And later she said that he used the shotgun, fired the shotgun. And I said, it was a double wide. I think I would know if a shotgun had been fired in the ceiling in a double wide.
Okay. So after that interaction between Kathy and Kevin, were they estranged from each other for a while? But it sounds like she would kind of change her mind about who she was close with or wanted to have communication with. Is that?
Yes, because she called Kevin the next day and said, I'm sorry, come on to Washington DC with us. And Kevin said, I already told my cadre, my leave's been canceled.
Okay. Are you aware of threats that Kathy had made to commit suicide?
Yes.
How many are you aware of, if
I'm
you know?
aware of 5.
Okay.
No, 6.
I'm going to show you what's been marked as Defense Exhibit 14. See if you recognize this.
Yes, I do.
I'd like to admit Defense Exhibit 14 into evidence, please.
Objection,
No objection, Judge.
be received.
What is this exhibit?
I wasn't sure if Kathy showed that to me. I wasn't sure if it was blood or a magic marker because I didn't see it physically. She said that it had something to do with a song she was listening to. And she was upset because of the divorce.
And you can't quite see it now, but did you see a video of, so you can see the triangle for play. Had you seen the actual video of this?
Yes.
In it, can you see what's written on the left side of Kathy's arm? I mean, you can't see it right now, but do you remember what it said?
I don't remember what it said because it was just so horrific that that she was doing this to herself.
I'm coming up here, so don't forget to give it to the clerk. Have you actually called law enforcement on occasion when Kathy made suicidal statements to you?
Yes.
All right, so you said you know of about 6 threats. What about actual attempts by Kathy to kill herself? Or was that the 6 and I misunderstood?
Those were the 6 attempts.
Okay. Can you describe some of those for the jury?
Yes. So the first one was while she was still married and she was very upset and she had overdosed on her trazodone. And she told me, I was in Key Largo and she lived in Key Largo at the time. And I said, I'm gonna have to take you in right now to emergency room. You're gonna die. And she said, no, I'm not going in.
Ms. Detman, it's okay. You don't have to give all of those
Okay, I'm
details.
sorry.
That's all right. I understand. So that was one attempt. What about other attempts that you're aware of?
So the second attempt was when she was in Port Charlotte. I had to go over the fence and open the sliding glass door. And she was in her bed, all dressed in black, and with a revolver in her hand.
And had she done anything with any medications that
Yes, she
time?
had overdosed on the oxycodone.
Did she end up going to the hospital that time?
Yes.
Any other attempts that you remember?
Yes, yes. There was another attempt with oxycodone again about 4 months later. Then there was an attempt with medication and Everclear. The second attempt, she went back to the emergency room and was admitted, Baker acted. The third time, when I called Port Charlotte Police, they got there and said, she appears fine to me. If she wants to drink in her own house, that there's nothing we can do. And then the most recent time was just in August of this year, August 21st. She called me and said she had overdosed on metoprolol, her heart and blood pressure medication, because the other ones didn't work. So she said, I did that. And I said, have Collin take you to the ER. No, I don't want to go. Have Collin take you. Finally, I talked Collin into taking her to the emergency room.
So, to your knowledge, Collin was home when she overdosed and actually had to drive her to the
Yes.
emergency room
Yes.
in August of 2024.
Yes.
You mentioned that Kathy had been Baker acted. Was that more than one time?
Yes.
The jury has heard a lot about some things that Kathy claimed that were maybe not true. How would you describe Kathy's reliability or her reputation for truthfulness?
Objection, Your Honor.
Judge, can we go sidebar?
Honestly, I don't understand. So, thank you, Kai, for that. It's like, why is Han Solo not objecting as she's reading? She's like this. I don't know. How can it? She's like, I mean, it is like I understand. Probably she is nervous, but there's occasions that she speaks up and looks at the jury, or and looks at that. But I don't know. It's a bit weird. But again, without like I can't. I hope you guys can at least hear something. I'm trying to boost the sound and go up and down when Chicken Lips goes in front of the mic and talks, but much more is just okay. Maybe I am the one that's wrong. Probably there's a high probability I'm the one wrong. That's probably the normal. But I get she's nervous. It's a hard situation. She's there for her grandson, and her daughter is nothing. But like I was saying, I want to see footage of Collin taking the mom to hospital, because if she had cameras all over the place, there is footage of that. And I want to see the records of the Baker Act and the unaliving attempts that Kathy had. Not that I'm saying that because she had those situations happening, the unaliving, the attempting unaliving herself, and the Baker Act, and that means that Collin was dangerous. I'm sorry, Collin was in danger. And that doesn't mean that he could just unalive her because she tried to unalive herself. What's that defense for? Yeah, true. Yeah, fair enough. Like in terms of her reading, yeah, probably I'm wrong. But the fact that I want the footage of the ring cameras that if Collin supposedly took her to the hospital, I want the footage of that, because if there's cameras all over the place, there's footage of that, and they can bring that very easily. She could bring that into and saying, is this Kathy? Is this Collin? Is this him taking the mom to the hospital after she tried to unalive herself? I want to see that. And it's exactly, and that is completely what I'm trying to say, Kay. Just because you are with those kind of thoughts, it doesn't mean that you can unalive it. No, it's just that line of defense doesn't, first of all, and doesn't suit me, because I'm sorry, yes, she was your daughter, so you're taking your son's side. Yes, your daughter might not have been perfect, but come on. Yeah. I think I agree. It's yeah, we need to call the police to this court pace. I think we do, definitely. Um it's just, but this case is making me angry with this not him, because he's not the one, but the lawyers are making me angry with this line of questioning that they ask. I cannot wait for Han Solo cross, and I need it to be good and to be spicy. And in terms of, like, yeah, there is a lot of trials starting, a lot of pages moving, so we are definitely in the swing of things, but some of them, I'm not half of them are not even being televised. So because I think, there's a lot too many ongoing that is not finished and everything, and I don't think at the places normally where do the feeds they can do that right now, because they already have a lot of trials going on. But yeah, it's just, I'm sorry, but I this line of questioning, and the way that they are trying to put that just because she was a bad mom, and because she was overdosing, and because she was taking trying to unalive herself, that was okay for Colin to unalive her, because basically that's what they're saying. They haven't said anything about abuse. They haven't said anything about other kind of stuff. She still provided him stuff. He was still going to Starbucks every day. He was still had a brand new car, didn't he? So it, yeah, she's blaming Kathy for sure. That is very true. Grandma is blaming Colin's behavior on Kathy. Kathy was blamed because Colin's behavior. So then, if Kathy was bad, then whose fault is it, Susan? Is it Robert's? Because apparently everything that is bad, it goes be Robert's, her ex-husband. That's what she's saying, because she said earlier that Robert is inconsistent, sorry, and a liar and everything. So she's perfect as well. Then so she and Colin are the perfect of the family. Kathy and Robert are the black sheep. I think that's probably what she's saying. So it's like, I understand it's a very hard situation, and like, I don't want to be in her place. She has lost her daughter. I don't know how her relationship with Charles was, but probably not very good. Apart from seeing the court records, that was not very good, the relationship between them two, because they had protective orders against each other. So it's just interesting to see their relationship, how it is, because I don't know how I am within her testimony. I'm not saying Kathy was perfect, far from it. We have seen that she was not perfect, but who is it? Yeah, it's like, yeah, the research from Oklahoma that Charles and her did not, I don't think, had a very good relationship, because there was two protective orders for each other. And I think we are back on the seal, because we're still on the sidebar. It's a long sidebar. I mean, it is. I wonder what they're discussing. I think they might have to do a break for the jurors if it carries on, because. Oh, here we go. We're back again, I think. I think the judge is going to give her jurors a break, maybe? No, we're just going to carry on. We'll be quiet.
Ms. Detman, I'm going to go through some individual things and ask you about them, okay? First, I'm going to approach with defense exhibit number 17 as it's been marked. Just read it and see if you recognize it as being a text from Kathy to you. Do you
Yes, I do.
I'd ask that defense exhibit number 17 be admitted into evidence.
Any objection?
No objection, Judge.
It is received.
In this text from June 27th of 2024, Kathy says that she was here and pressing charges, going to 77 Hewlett Drive. That's your address, correct?
That was the address in Auburndale.
To check on you and to pick up Inaki for charges of attempted murder and assault against you. Meaning she's claiming that Inaki actually tried to murder you, correct?
Yes.
Is that true?
No, he's never tried to murder me.
So that's something that Kathy threatened and claimed that just simply wasn't true, right?
Exactly. Yes. Yes.
Has she done that on other occasions, make things up?
Yes. Yes. She made up that I was diagnosed with Lynch disease, which is it's an auto-recessive disorder where people have to have, they're more prone to cancer. So she said that her insurance company was forcing her to have a hysterectomy because of that. She also told Christy, and Christy was so distraught.
Okay, Ms. Stepman,
I'm
I'm
sorry.
sorry. No, it's okay. I understand. So she made up that you had a disease that you do not in fact have.
No, I verified with my oncologist that I didn't have.
She also made up that John Paul Volantis had been neglecting his child, right?
Yes.
Has she ever made anything up about Robert Volantis?
Yes.
What did she make up about Robert Volantis?
When she was younger, she said that Robert raped her.
And how do you know that that's not true?
It went to court, so I don't know. I only.
Did she ever tell you that she had made it up?
Oh, yes. Later, as an adult, she told me she had made that up.
Did she say why she made it up?
Yes, because she was mad at the situation between Robert and I.
Okay. Has she ever made anything up about her being responsible for everybody else's successes in the family?
Yes, she went as far to say that no one in the family would have any of their degrees, and that she, in fact, the only reason that I got my doctorate was because of her.
Okay. And did she actually make a threat to you regarding this
Yes,
belief she
did.
had?
She said she was going to, when she was mad at me one time, she said she was going to contact the university where I work at, and I said, go right ahead. No, I had to.
What did she tell you she was going to?
She said
say
she's
to
going
them?
to call the university, my dean, and tell him that she did all of my coursework and that I didn't do anything and that I was a phony.
Did she make up at any time that you're aware of that Collin was failing school?
Yes, she said that he had been failing school and that when he was staying at my house, that it was my fault because I wasn't observing him on the computer to make sure he was doing his work.
Was Collin ever failing to your knowledge?
No,
When did Collin graduate from high school?
he graduated last June.
Was that actually ahead of schedule?
Yes, that was a year ahead of schedule.
And did he, in addition to graduating early, did he ever, did he get college credit?
Yes,
At the same time.
He was dually enrolled in college.
You mentioned earlier that you had paid for some trips the trip for Kathy to go visit Robert Willantis and meet his mother.
Mhm.
Did you pay for other trips for Kathy?
Yes, the cruises that they went on, I paid for.
And the other trips that the jury has seen pictures of Kathy and Collin, who paid for all of those trips?
I did.
Did you also have, you mentioned points and using points for things.
That's our DVC, our Disney Vacation Club, as well as I have points through Hilton Honors.
Have you ever witnessed Kathy not being able to control her temper?
Yes,
Can you describe some of those
yes.
times?
She went at,
Your Honor, if we may approach for a moment. Another sidebar, the headset that Mr. Griffith is using is on mute somehow. I can't figure out how to unmute.
Finally they're talking about the headset.
It doesn't appear to have any buttons on it at all.
Finally.
I may not just know how it works.
I'm certain that it's plugged in.
It indicates that it's on mute. It has like a little, that's the one I've been using.
I think finally they are fixing the audio, guys. This must be it. That was a call. But hey, welcome back, Nightbot. Sorry, thank you very much for doing those, Nightbot. Appreciate you. But the thing is, Grandma, that I'm saying, guys, tell me, how much do you guys want to bet that when is the prosecution time Han Solo to cross? Now she remembers everything. She knows all the details. She says, yes, I remember. Yes, I remember. When it comes to the prosecution time, it's going to be, I don't know. I don't remember. It was so long ago. I don't know. No. How much, guys, do you want to bet? Let's make wagers in the chat. Tell me what you want, and we'll see who's right, and then I might not. But it's just like she knows everything. She's like, boom, boom, I know everything. Emphysema, I'm not paraphrasing what she said. Emphysema, cancer, essay, this, that, was lies, was true. Kathy was this, Kathy was that. When it will come to the prosecution, she will not know anything. She doesn't know her name. She's not gonna know where she is. She's not gonna know who is the president. And she's not gonna know anything. How much guys want to bet that that's gonna happen? Always happens with any case, with any prosecution defense thing is they decide that as call them off. For example, this is a defense witness. She knows everything. She is the go-to person. She was there all the time. She was the queen of the family. She was there 100% of the time. But when it comes to the prosecution, she's not gonna know anything. I don't know. I don't remember. Sorry, I'm glaring again. I am working on it. I do have another curtain that is coming to stop the glare from here. So my apologies. Hopefully the sun will go away. I mean, at least we have sun in the UK. Yay. But yeah, it's just like her testimony. It's like it is still sad and everything, and it is hard. It's a hard case altogether. Any case we cover, it's a hard case. But it's just so weird that she knows everything. She doesn't say I don't remember or no anytime, and she's on the ball. Yes, and I want to know. And Kathy was apparently Kathy. I'm sorry, she was almost saying that her own daughter was almost the devil. Ma'am, you raised her. Who raised her? Was you and probably Robert. Are you saying that everything is Robert's fault again, and you are the saint as well of the house? And it's just like, if she was that bad, something must have happened when she was a kid. people don't turn back. Like, there is evil people that are born evil. Don't I know? But something must have happened when she was young. Like, the accusation that she did when she was young. That she came to you, trusted you, and you basically told her that she's a liar. And apparently they went to court and whatnot. But still, ma'am, you raised her. So whose fault is it?
All right, members of the jury, I'm going to ask that you step into the jury room for just a few moments while I discuss a matter with the lawyers.
Sorry,
All right.
if you didn't hear that, the judge is sending the judge back because apparently there's a matter to resolve. It might be the technology issue, because they were having issues on Friday with the technology. So let's hope that it is that and that's something else. But apparently there was an objection at the same time that there was the mic's issues. But we'll see what's happening. I did just check that our new case, the jury selection has begun. But what they said was, if the jury it is picked today, the court will only start the case tomorrow. So we might not even lose anything again, like we did with this case. Amazing, fantastic. I like how the court is working out for us. So that is great. So I don't know what we are waiting on. Yes, it will be televised. Our new case, it will be televised, and we will be following it here. Okay, that's gonna be our next case after Collin finishes. So, like I was saying, it's back to back cases, which are amazing. We are talking now. I think they're gonna. I don't know. Ooh, there's a lot of text message there on his land. Oh, this glare. Sorry. It feels like I'm in a halo or something, like here in the corner. Maybe I am a saint. No, I'm joking. I am further beyond the saint. I don't know what Chicken Lips is doing. I don't know what's happening. The audio keeps coming in and out. Chicken Lips is organizing some text messages. She has quite a few things. It feels like she has a good binder of them there. So we might stay here for a while. I mean, I wish we could be hearing any of this. I'm trying to see if I can read them from here, but no, she moved in. So no, I don't think she's packing Nightbot. I think she's just looking at the messages. I don't know what's happening. I think the judge is looking something on his computer. They were trying to fix some technical issues they had earlier. No, the jury's not back yet. The jury's just went out. This is outside. Whatever is happening is happening outside of the presence of the jury. So, good morning. Well, yeah, yeah. Good morning, Toxic. It is Monday. Monday sometimes are hard. We are right now waiting for what's happening because state has arrested girl. So we are on the defense case now. JOA was denied. Now we have Grandma on the stand, Collin's grandma, Susan Defman. And the judge is trying to speak, but I think court is it's Kimpy Pig. I don't I don't understand you, Nightbot. Just text me, DM me, Nightbot. Judge is talking, but we can't hear him. This
As for reputation,
hope you guys
Two
can hear this, because
instructions, one when the reputation is known, and one when it's not, but it's offered to prove that the alleged victim acted in conformity with that reputation, which is, I need you to talk me through how you're doing that, or are you not using that?
No, I think it is relevant because the defense is that Kathy grabbed the knife in the house in Auburndale, and that fits with past instances where she pulled a gun on Collin, where she attacked Inaki with a baseball bat and said she was going to get a gun, where She pinned her then husband against the house with a car, that she stabbed her husband and burned him, and those were in front of Collin. And she has independent knowledge of those too. So those are the specific instances.
Judge, I have nothing further to elaborate on besides my objection in the hallway. And I object to anything that will be contrary to what Your Honor just read in the jury instructions, Your Honor. It might be it might be a question by question journey to see what, if anything, is admissible or relevant based upon the application of the question asked by Ms. Thornhill, the jury instruction differentiating between, as Your Honor pointed out, the reputation or things that the defendant has to have been present for, have personal knowledge of, and Ms. Detman, depending on how narrow, or maybe I should say how wide her answers are going to be.
As far as her reputation, it's my understanding that her reputation within the family was for being dangerous and violent, and people were scared of what she might do at any given moment. So I was going to ask about both.
While I understand the community for purposes of this type of reputation evidence may be narrower, you're still going to need to lay that predicate.
Sure.
This is a family of estrangement, after all, it seems. So
Because of her violence.
Well,
yeah.
But I don't know who's estranged from who else. So
Well, and it,
she needs to understand and know that family community.
Okay.
So
and even if somebody's not still a part of that community on this particular day, I mean, they all.
I'm not suggesting it has to be at some particular instant in time, but I haven't heard a lot about her closeness with others who may share that in that reputation or have knowledge of that reputation.
Okay. I will do my best. Is
And
this
we'll
our-
just take it question by question as Mr. Levine suggests.
Okay.
You want to go ahead and just take our mid-morning recess?
That's what I was gonna ask, if I could run fast.
Mr. Levine?
Yeah, that's fine, Judge.
All right, we'll take 10 minutes.
All right, so while court goes on break, I'll stay like this kind of a little bit because I can stop the glare for a bit. So just do a brief recap from this morning. This morning has been a wild morning already so far for those coming in. So as soon as we got in, we could not hear the judge. We barely can hear the judge. I have my volume to the max with 2 boosters, and it's absolutely crazy the sound, so can't hear it. And Collin is Collin her only grandson? Did her other grandchild, if any, of no, Collin has an older brother. I think his name is Christopher, but I don't think he's an alive. It's just, yeah. He's, I think, a normal person. It doesn't want
A lot of times he needs like a shock. Good. Put it down.
I think I just died. Guys, I'm so sorry for that. I still had the audio boosted like I've been doing for court. And they came back and apparently they have fixed the audio. Yay! Ow. So, yeah, he has an older brother named Christopher, and I think he is, yeah, he's an, well, what can you call normal, but it is normal. But yeah, yeah, he has, exactly. That's the thing. Is like, I'm not saying that Kathy was perfect. No one is perfect. I'm sure Kathy had a lot of her wrongdoings and a whole wrong bad characteristics like everybody else does, but no one deserves to be unalived. So now the Chicken Lips, I don't know if you guys heard, but Chicken Lips was saying that Collin grabbed the knife. So they're not on the theory anymore that she fell on the knife. So they're saying that Collin grabbed the knife. So now they're changing their theory again. Because first she fell on the knife, then in self-defense, and then he grabbed the knife in self-defense. Well, it might not be a parenting problem exactly, it might be a gene or a mental problem, but then that's the thing. How can someone, right, from the dad side and the mom side, analyze both parents within a year, both in self-defense? I'm sorry, but that's too much coincidence. It's just not. I'm sorry. I'm not believing. How can you analyze someone? And then the thing was, if Kathy was so unstable, so bad character, I can't say bad character or anything. So why did not go when Christopher Colin was supposed to come live with Kathy? Why did not the grandma stop straight away and call Child Protective Services or CPS or the police or whatever and said and raised concerns? Why did not grandma raise concerns to the police if there was that much of instability from Kathy's side? Even though Kathy was like taking him out of the Baker Act facility or and whatnot, grandma, she should have done something then. Why didn't she do it something? Why nobody else did? Why not? Like, probably they don't get along, Christopher. But I would like to hear from his side as well. I know he probably doesn't want anything to do with this, and I think he said he doesn't want to do anything with this as long as he doesn't has to come, as long as he is not subpoena, he doesn't want to get involved. But I would like to hear from someone that probably it's a little bit less involved in the family to tell exactly how the family was, because he grew up in this. Um, you know, he either grew up with a mom or either grew up with a dad, or something else happened and he grew up outside of that house and might grown up with with a grandma. Um, yeah, but don't you agree, Toxic and everyone, that they have changed their claim of self-defense? Because they started with she fell on a knife, and now Chicken Lips was saying he grabbed the knife. So which one is it? Is it left or right or center? You shouldn't be able to swap your defense in the middle of the trial, because now which one is it? He fell or he grabbed the knife? Because now she's saying what the Emmy is saying, and it's like, ooh, that thing of probably falling on the knife won't go with the jury. We need to change to you grab the knife. So then again, I don't know, because Grandma Susan is saying that she paid for everything. I'm sorry, did she have the millionaire's pension? Because I don't. Well, it true might well change in the next half an hour, because the thing is, unless she had a millionaire's pension, I want to know. Like, she was talking about she used points and everything, but yet for you to have points, you have to spend money. The companies don't give you points just because you're a customer. You have to spend money to get the points. So where did she, like, I know, like, did she, how much is her retirement? Is she reach? I want to know, because I mean, if I was Colin, I would carry on playing the self-defense key. If he wins, go live with grandma, and he thinks that probably he goes live with grandma, and life is gonna be a life of strawberry fields, that nothing is gonna go wrong. But if he does find guilty, I'm expecting we'll be back in about 2 years with this case again, with this kid again. And then he's going to be an adult, and it's definitely not going to be charged as an adult. So, sound in, sound out, but it sounds better. So I know it is. I 9% agree with you, Toxic, that it's either one or the
Are
other.
y'all still discussing this stuff?
Okay, sounds.
She's still on the stand.
But I don't think they are. It just keeps me, but it's just like this defense already started. This is the first witness of defense. I think so. I think no matter what the outcome on this one, they're gonna reopen the Oklahoma case, because if this one it is self-defense, okay, fair enough. We're about the dad, then I'm even more about that. But then if he is found guilty on this one, 100% sure they are opening the Oklahoma case, because that is, and if there is a case in Oklahoma, we'll be covering that one too. If we're not in the middle of a trial, well, we can adjust to that, but we'll be following that one because I want to see. It is exactly as like I don't know. I think Denise put me on the fence and I was cemented to the guilty side because I'm always there anyway. Um but now it's like the mom wasn't perfect and I get it. No one is. And I don't think nothing amounts to the fact of unaliving another person. The only thing is if you are in a minute threat, but it wasn't. Mom didn't have any PP with her or a baseball bat or anything with her. There was a knife. So unless they fought, right? They fought and he grabbed the knife from her. But then again, he would have self-defensing wounds. He would have her DNA underneath his fingers in his fingernails, and he didn't. So the fight claim, for me, it's a big bogus. Because how can you fight with someone and not get their DNA or scratch or do anything on her, on yourself? And then again, it goes because the defense was saying, oh, she went in voluntarily into the house, she walked. Then if they were fighting, like by dragging her, you would not get DNA underneath. I don't know. I am more on the guilty side than on the lesser. I think I'm not on not guilty. He's guilty. I'm not on the not guilty. I'm either cemented to the guilty side or maybe guilt on the lesser. I need to listen a little bit more to the defense claims to see exactly where I am. But I think I am like that. What do you guys think? Oh yeah. A scrub out family. I'm sorry. I think the only person that is actually might be. Yeah, they do. But I think Oklahoma is waiting on this. This and living. I don't think it has. They are just waiting to see. But this is my humble opinion. But by the way, before I forget, don't forget to check the Discord server. Discord has also a lot of new stuff. We have a YouTube channel. We have a Twitter X account. Make sure you follow there. And I'm gonna ask Toxic to put the Buy Me a Coffee one to if you want to support the Discord server, for them us to be able to get documents of certain cases that are behind a paywall. It can support us that way. No, she didn't. She did not have DNA underneath. So that, for me, abolishes the claim of self-defense because to be self-defense, you have to be in an immediate threat. You have to be in danger. And then how can you be in danger? And if you don't have any, like if you were fighting, you would scratch her. I'm sure you would scratch her mom and everything. But it's just impossible that he did not have any DNA of her underneath his fingernails. And if you did CPR, right, especially in a neck wound, that if there was a Red Sea, right, you would have some blood underneath your fingernail because they would get into your fingernail. They would. And he didn't. So how can you do CPR in a sea of blood and not having any marks? And a question that the prosecution did not ask. So if he was on the floor, right, by her chest to do CPR where you should be, your knees would be marked as well with the Red Sea. That would be on the floor. But it wasn't. There was no mention of it. So because they told us that it was at the head of her mom doing CPR. So that is my other question, because he only had bits of blood in shorts and the shoes, because apparently he wasn't wearing a shirt, a t-shirt, which I think he was wearing a t-shirt. he took it off, washed it, or put it somewhere that they did not find the t-shirt, and that t-shirt will have the Red Sea splatter. Sorry, that's what I call, what goes in our veins. Because I don't know if we can say that on the YouTube. That had the splatter on it to tell the direction of where the stabby thing that he used on the mom, because that can tell you a lot how the transition and goes. Sorry, I watch way too many crime shows and way too many trials to to know all this information. So I still have a lot of questions, and the questions that I haven't been answered so far in this trial, and I don't think it is going to be, because it's a prosecution question and not a defense question, unless the Han Solo puts that on rebuttal. But I don't think he's going to put a rebuttal. Oof, it looks like we are back. So thank you very much for that. If you want to support the Discord server with Buy Me a Coffee, the link is in the chat. Thank you very much. Hopefully the sound will be better now. And again, his hands. Does his hand? We never saw his hands. Does his hands always been inside of the pocket?
Yes, sir.
But anyway, we'll carry on this chat on the thing. That's a very green tie from the attorney. Okay, we're still waiting. Probably we're gonna be waiting for the jury to come. So yeah, sorry, just checking a couple of bits, because I'm trying to keep an eye on the jury selection for our next case, and there was an article came out, because yes, I have notification for articles to come out, but he was just talking about the jury's hasn't been seated. I don't think it's gonna take probably the whole day to seat a jury for that trial. Yeah, so we're just waiting for the jury to come back to resume the morning session of our trial. It's been a little bit heated. I'm not gonna say spicy, but it's been heated in terms of this witness. I don't know if I'm believing her. It is hard. Sorry, I need to keep my hand there. It is a little bit hard to believe her. I don't know. She remembers too much, and sometimes you have, as a witness, you're like, yeah, it's the balance of remembering too much and remembering too little. And I'm sorry, she has a very good memory right now. She has a perfect memory. I mean, she remembers everything. And now I want to see how on cross she behaves, if she's gonna remember as much as she's remembering now. So hopefully we're going to carry on. There might be a lot of more objections on this part as well, so keep me right with the objection counter, because apparently what the Han Solo said was they are going to carry on trial. Here comes the jury, but they are going to carry on. He's going to carry on objecting as they go to I think it's text messages that Chicken Lips is trying to introduce. So we'll see what happens there, and go from there. Yeah. Oh, I forgot to show you the guys the pastry, didn't I? Oh, I forgot again.
Please be seated.
Guys, remember me. Before I start talking on the lunch break, remind me of showing you. I'm probably gonna eat one now, because I am a little bit peckish.
Ms. Detman, I'm going to ask you about some specific
And I'll show you the other one
instances,
later.
and may ask you to describe a little bit about them. So starting with, are you aware of Kathy having pinned her then husband to the wall of the house with her running car?
Yes, ma'am, I know.
Okay. And were you present for that?
No.
Have you ever, are you aware if Collin was aware of that incident?
Yes,
He was aware.
yes.
What about an incident where Kathy stabbed her then husband with a corkscrew and then burned him with a terrarium light? Are you aware of that incident?
Yes, ma'am.
And are you aware that Collin was present for that incident?
Yes, ma'am.
Are you aware of Kathy threatening to kill her then ex-husband's girlfriend's family in Homestead?
Yes, I am.
Are you aware that she actually started driving toward their house to follow through on her plan?
Yes.
Did you actually speak with her on the phone then?
Yes. I was telling her that what she was doing was crazy. She was going to get in trouble, that she couldn't take it out on 3 innocent lives in Homestead. She needed to turn around and go back home.
Are you aware if Collin was aware of that incident?
I'm not aware.
The incident where you said Kathy attacked your husband with a baseball bat.
Yes,
Are you aware if Collin was aware of that incident?
I'm not aware of that.
And have you ever personally witnessed Kathy engage in a physical act of violence towards Collin?
I know that there was a fight at the house in Port Charlotte, and the fight started because she was beating him with a belt and making him do push-ups, sit-ups, push-ups, and then holding a weight above his head while he was running in place.
Okay. When you say that she beat him with a belt, were you actually there for
Yes,
that?
I was, and I tried to stop it.
Right. What about, are you aware that Kathy pulled a gun on Collin?
Yes, and then later she said that she denied it. Then she said yes. She pulled out the gun and handed it to Collin and said, "Just kill me, shoot me."
So she actually admitted that to
Yes.
you.
Yes,
And obviously Collin was aware of that because he was the one who was present with her.
yes, and Corporal Rendas was aware of that also,
How was Corporal Rentis aware of this?
because he and I and Kathy were talking about that. There's a difference when you take a gun out and give it to somebody and say, "Here, kill me with this," versus somebody pulling a gun out and putting it to their head or to their chest.
And so Corporal Rentis was a part of this conversation where Kathy admitted she pulled a gun,
Yes.
and she said she handed it to Collin.
Yes.
Did she ever admit that she actually threatened to kill Collin with it?
No, she never did.
Within your family, we've talked about some of the family members. Despite some of the estrangements that Kathy had, would the family sort of maybe not talk to her for a while and then everybody would come back together, take trips together? I mean,
I was the constant in her life. My oldest daughter didn't talk with her while she was married.
okay, what I'm asking about is, did the family talk about Kathy with each other?
Yes,
And whether or not Kathy was estranged from anyone at any one particular moment, did the family continue to have discussions about Kathy?
yes,
And was there, did Kathy have a reputation within your family as being violent?
yes,
Did she have a reputation as being unpredictable
yes,
and volatile?
yes.
Despite all of this, did you still love Kathy?
Yes, very much, very much. I always wanted to help her.
It appears that Kathy at times wanted Collin with her at all costs, and then at other times wanted nothing to do with him.
Yes, when she had Collin back for about a month, she spoke with me and she said, Mom, I have to get up every morning at 6 o'clock, take him to school, and then I have to go back and pick him up. And I said, you don't have to, let him ride the bus.
Okay. I'm going to show you what's been marked as Defense Exhibit 26 for identification.
Sorry, what number is that?
26. Will you read this and see if you recognize it as a text from Kathy?
Yes.
And ask that Defense Exhibit number 26 be admitted into evidence.
Any objection?
No objection, Your Honor.
Be received.
In this particular text, it's Kathy saying she's done with this, and she can't take Collin to school anymore.
Yes.
So that was a specific example of what you just described to the jury.
Yes.
As part of this vacillating back and forth that Kathy seemed to have about whether she wanted to have Collin live with her or didn't want Collin to live with her, did you all agree eventually to a concurrent custody plan?
Yes, we did.
And that was something, did anybody force Kathy to sign those papers?
No, not at all. Not at all.
Were there times when Kathy wanted to cancel the 751 plan, the concurrent custody plan?
Yes.
And then would she change her mind back?
Yes.
Okay, so it's safe to say she wasn't consistent.
She was not consistent.
Obviously, Kathy owned a gun, right?
Yes.
So at some point, did Kathy give her gun to you to have it out of the home in Fort Charlotte?
Yes.
Do you remember when that was?
Yes, it it's right after the incident where Officer Rentis and Lacey got involved when Collin came back to the home. So that must have been somewhere in the October timeframe of 2023.
Okay. How long did you have the gun at your home and away from Kathy and Collin's house in Fort Charlotte?
Less than a week.
Okay, why did you have it for less than a week?
Because she demanded that I give it back. She said, it's my gun, you can't have it. And I said, but we discussed with Officer Rentis and Lacey that I would keep it. No, it's my gun, you can't have it. And how do I know Nikki won't use it to kill you?
Okay, so Kathy got the gun back, and
Yes.
so far as you know, she had it with her.
She had told me that she had given it to her next door neighbor, Melanie, for safekeeping. And then a couple months later, she said, no, Mom, I lied to you. I've had it all along.
Okay. Finally, you had a lot of communication with Kathy on September 7th and September 8th,
Yes.
right? You also had communication with Collin during that time.
Yes.
Did you allow Collin to go to your house in Auburndale when Kathy kicked him out?
Yes.
And why did you allow that?
Because a child can't be just roaming around the street by himself. Collin told me he didn't have gas in his car. You know, he had like half a tank. That was it. He didn't have his phone. He was using his computer somehow to talk with me. I told him, I said, you have to get to Auburndale before dark because otherwise the gates will be closed. During the day, the gates are open. And go in through the back sliding glass door because you know there's no lock on the back sliding glass door. And I will be there Sunday. Don't talk to anybody and don't leave the house.
At some point, obviously, Kathy, as the jury's heard on some videos, was trying to find out if Collin was actually at your house.
Yes.
When did she finally discover that he was at your house?
I let her know around 11 that night.
On the 7th, so
Yes.
Saturday the 7th? And how did she react?
She said, you lied to me. And I said, I told you I didn't know if Collin was there. I said, because I don't want you going over there and grabbing him. You just threw him out. Give him some time, give you some time. Let's not have a huge problem associated with this.
And aside from conversations that the jury has heard between you and Kathy over the next hours, did you specifically tell Kathy not to go to your house in Auburndale?
Yes. I said, I will be going Sunday morning. I left first thing Sunday morning. I was going to leave right then, but I was so tired and I have difficulty seeing in the dark that I thought, no, it's better that I wait. You know, in hindsight, I should have gone. But so I waited. I talked to her. She said, no, Mom, I'm going. And that's when she said, I sold the car. They're going to come by and pick it up. I said, you can't sell Collin's car. It's his car. No, I don't care. I'm selling it. I'm turning it into his probation officer for not, because he's not allowed to leave the county, which when I talked to the probation officer, I found out that Kathy had told them that I had terminal cancer. So therefore, Collin could come and visit me anytime I want. I had to tell the probation officer, well, right now, I'm only at stage 3, so no, you know, and I'm only in observation, so I'm not terminal.
Okay.
So,
But you personally told Kathy, do not go to Auburndale.
yes, I told her, I said, when I get back, I will give him gas money and I will follow him there, or we can wait until Monday morning. Let's just wait. Don't go there. You don't
Why-
have permission to go.
Why did you not want her to go to your house in Auburndale?
Because I didn't want her to start a fight with Collin. I was afraid that she would be combative, maybe go after him with a baseball bat, a gun, something.
I don't have any other questions, I don't think.
Thank you.
I don't have any other questions, but Mr. Levine does.
Mr. Levine?
Thank you, Your Honor.
Good morning, Ms. Stedman.
Good morning, sir.
Ms. Stedman, I know you're going through a lot with the loss of your daughter and cancer and everything else. But I'm gonna need to ask you some questions if that's all right with you.
Yes, sir.
Now, today here in court in front of the jury, you've talked about that you were concerned that Kathy was going to attack your grandson, and then you listed a bunch of different weapons. But weren't you more concerned that your grandson, who had killed someone before and had been violent countless times with your daughter, weren't you concerned that he was the one that was going to attack your daughter?
No, he had not been violent countless times with Kathy. Kathy had been violent with him countless times.
Now, a lot of the things you've said here today, you never bothered to tell me or law enforcement or anyone.
Objection. Judge, it's improper impeachment.
Sustained.
Ms. Detman, as it pertains to your grandson, do you talk to him a lot on the phone since he's been in jail?
Yes,
Okay. Do you do any emailing with him?
I don't email with him while he's in jail.
You-
No,
you
just
prefer
talking
to-
on the phone.
Talk with him? All right.
Yes.
And how many times a week would you say that you talk to your grandson on the
I
phone?
usually talk to him 3 times. I encourage him to pray. I ask him if he's eating. I mean, I'm a dietitian, that's what I do. That he's drinking his milk, that he's exercising in his cell, and most important, that he's reading books. And I keep telling him, you have got to pray. You have got to read your Bible.
Now, I mean, this is an obvious question, but you love your grandson, correct?
Yes,
Your daughter is dead, clearly,
yes,
and she's not coming back, correct?
no,
Now, would you agree that you don't want to see the defendant have to go to prison for a very long time? Is that correct?
I don't want to see my grandson go to prison for something he didn't do.
All right. Well, you couldn't make it any more crystal clear that you're up there and all your answers that you've given have been driven by you believing that the defendant, your grandson, didn't murder your daughter, correct?
I am giving clear answers, sir, as to what happened. I know my daughter. That's why I didn't want her coming that day to the house without me being there. I wanted her to wait the next day so that maybe she could calm down a little bit.
You know your grandson too, correct?
Yes,
And you know his history, correct?
yes.
Now, you say you know what happened, but you weren't there when it happened.
No, I'm not saying that I know what happened. I know the possibility of what could have happened. I wasn't there, so I have no way of knowing. I just know the facts about Kathy, having lived with her and worked with her, even to try to maintain her sanity, to try to maintain that she could keep her job as a teacher, to try to maintain that she wasn't trying to slice herself and kill herself,
Okay,
and
let's-
not coming after my husband with a gun.
Okay, let's talk a little bit more about Kathy. Now, it sounded like she had some mental problems. Is that correct?
Yes,
Now, you would probably agree that it didn't help that she got impregnated when she was just a child, correct?
she was 13. She got impregnated when she ran away from the Hope House, and they found her in the hotel with her boyfriend. It didn't help that her father called her F bitches and that she was damaged goods, and he didn't want anything to do with her.
Ma'am, it sounds like you're really quick to try to throw dirt on your dead daughter. Would you agree with that?
No, not at all. My dead daughter did the best that she could. We have a problem in this country with addressing mental health. We all know that. And that's what she had. She had mental health issues. At times, she was the greatest person on the world,
All
very
right.
intelligent.
I appreciate that, ma'am. I appreciate that. Now, your daughter worked as a teacher for many, many years, correct?
Yes, she did.
And her students loved her, correct?
Yes, they did, for the most part. I mean, as with any teachers, you're going to have some students that, I mean, I'm an educator myself. You're going to have some students that don't. For the most part, yes.
And she cared about her students, correct?
Yes, she did.
She had a passion and a love for teaching.
Yes, she did.
And she taught, predominantly she taught English, correct?
Yes.
And she cares so much about her students that at a certain point, she let one of her students move in when she was married to her ex-husband, Chuck, correct?
Yes.
And then, unfortunately for your daughter, Chuck took advantage of this underage student, is what it's believed to have happened, correct? And
Judge, I'm gonna object to the relevance of all this.
Approach.
Guys, it's getting wild. What the absolutely, oh my gosh, is happening in here? This is getting wild. This is getting so wild. I know absolutely what the, I can't say the other word, but you guys know. I was like, what is actually happening? Like, so it's the dad's fault that she got. Oh my days, this woman is so delusional. I'm so sorry, but it's just, oh my days, it is just so wild, just absolutely wild dreams that we are actually witnessing this. Oh my days, I don't even have a words to what to say, because it's just, wow, she is. So in what world, right, with the school let someone so unstable, first of all, work in a school, and second of all, take a kid home? True that this happened after, like, the instability happened after, but I'm sure she had other problems before. This was not, the problems did not start only when Collin went to live with mom. I'm sure even when she was married to Chuck, Collin's father, Charles, they had their all issues and everything. So, oh my days, now makes sense, guys. Now makes sense. All the court documents we looked through the other day, or I saw the other day, and I told you about, because there is so many court entries against Susan, against Charles, against Kathy. This whole family is something else. There is, like, I'm sorry, I'm not surprised that Collin is a little bit bat crazy, but it's just but it's just crazy. Like, no wonder he end up like this again. Like, now we can see, but that still doesn't give him the right to unalive his mom. All right, let's get that clear. Nothing got the right to unalive, especially this way. But the state went, I think Han Solo, he's very peaceable, right? He's just very calm, asking his questions, but he's going there. He's going where he needs to go. And I'm loving it. And I am here for it. And I am so excited. I'm literally glued to my chair. I don't I don't want to move. I don't want to go anywhere. But the state is, I think, is doing a really, really good job so far. He's doing a good job in terms of trying. I don't think he's trying to impeach her, but he's trying to show that Kathy was not the only bad guy in the screen. That Collin was right to unalive her the way he did. Do you know what I mean? So, because what the grandma is saying, that, like, he was justified to do it, because otherwise it was either going to be Kathy unalive Collin, or Collin unalive Kathy, and Collin did it, and he did it in self-defense. And in a way, she looks, I'm sorry, glad that Kathy is not here anymore. Because I'm sorry, you lose your daughter, and you can go to an open public record for the world to see. Because I'm sorry, all eyes are on Collin. All eyes is on this trial. This trial has been very publicized. And you can talk to your daughter like that, about your daughter like that? The one you say that you're going to have a celebration of life later this year?
I'm sorry we have to talk about some unpleasant things, but it'll be over soon enough.
Thank you, sir.
No problem. So, do you recall my last question?
Yes. You were asking me why I was spilling dirt on my dead daughter, and I said, I'm not. I said, I supported her. I've gone into massive debt in trying to
Okay,
ensure
ma'am.
that she
I
had.
appreciate that, but that was a few questions ago.
Oh,
But-
you're talking about how Kathy ran away from the Hope House and they found her in the,
No, I'm not talking about that either, but if you listen to my questions,
Just ask the question.
it'll get easier. So we were talking about your daughter, that she was a very committed teacher and very committed to the youth of her classroom. And I mentioned that at a certain point, she even allowed one of her students to move into the household, and it was believed that Chuck had an inappropriate relationship with this student. Are you aware of that? With a yes or no answer, if we can start at that place, I'd appreciate it. Are you aware of that?
yes,
And you were not a big fan of Chuck as it ended up being the divorce, correct? For how he treated her, from how he impregnated her as a child through the years, being physically, emotionally, and mentally abusive to your daughter. I can't imagine you were a fan of that, were you?
no, Robert was the one that was a fan of Chuck.
Now, ma'am, I understand that you hate your ex-husband.
I don't hate him.
Well, it sounds like you're throwing stuff about Robert in a lot.
You just asked me if I was a fan, and I wanted to tell you who in the family was. I knew Chuck from the
Your Honor.
time he was.
Ms. Tetman,
I'm sorry.
that's the point. He gets to ask the questions.
I'm sorry.
To elicit the information he's looking for. If additional information is needed, Ms. Thornhill or Mr. Hendry will make sure to address it. So just pay close attention to the question that's asked and try to answer just the question that's asked.
I apologize.
That's all right. Mr. Levine?
Appreciate it. Ms. Stetman, as it pertains to your last piece of information that you provided, as it pertains to your husband, he hated Chuck for what Chuck did to his daughter, that being impregnating a little girl, correct?
I'm going to object to the relevance of, and to speculation about what Robert thought about Chuck.
Sustain as to relevance.
All right, Ms. Stetman, if I ask you a question that for your information, just please answer it irrespective of your feelings about your ex-husband, all right? Now, at a certain point, Kathy got divorced from Chuck, correct?
Yes, sir.
After years of unthinkable abuse, correct?
Yes.
Now, let's move on to a different subject matter. When your grandson lived in Oklahoma with his dad for about 3 years or so, at the end of that, your grandson wanted to come live with Kathy and actually was able to, correct?
Yes.
And Kathy was very happy about that, correct?
Yes.
And she felt that she had missed out, understandably so, on multiple years of her son's life, correct?
Yes.
And she was trying to fix or make your grandson's life better.
She was trying to improve his lifestyle, yes.
Now, you described it as a fight in Port Charlotte where law enforcement came because you said your daughter was beating Collin with a belt and made him do sit-ups and push-ups. You remember that?
I did push-ups, and I took away the sit-ups. It was push-ups and putting the weights above his head and running in place.
Okay, thanks for clarifying that. Now, you remember talking to law enforcement when they came out there, correct?
Yes.
And giving a sworn statement because you just wanted both parties, your grandson and your daughter, you wanted everybody to be safe and healthy and happy, correct?
Yes.
Now, Ms. Detman, as to the root of what the issue was that night, do you remember telling the deputy that the three of you were at the dining room table and Susan had Collin seated down and Kathy told Collin that she would be implementing new parenting rules and Collin would be having his Xbox, his cell phone, and other items taken away
as disciplinary action due to him being disrespectful to her. Do you recall telling law enforcement that?
I remember telling law enforcement about the Xbox would be, I don't know if it was taken away, but it was going to be restricted.
And at that time, your grandson didn't want to hear from his mom, and so he stood up and threatened to fight her and said, let's just do it, correct?
That was after the incident with the exercising and belt, the beating of the belt. That's when Kathy wanted us to all sit down and eat sandwiches. Like it literally went from one extreme to another. Sit down and eat sandwiches. And then Collin got up from the table and said, let's just do it. And I went to go get my phone to contact Officer Rentis or Corporal Rentis or Officer Lacey.
Okay, all right, very good. Now, you mentioned that you and your family members love to talk about how violent Kathy was. Is that right?
No, we didn't love to talk about how violent Kathy was. We talked about what we could do to help her. We didn't want her to lose her job. We didn't want her to be suicidal. And more than anything, we wanted her to try to get better.
Did you talk about how violent your grandson was?
No.
And why not? Weren't you concerned about that?
Objections.
Sustained.
Now, you were concerned about where the defendant would live, correct? In terms of who he might hurt, whether he lived with you and your husband, Nikki, or if he lived with Kathy.
My husband did not want Collin to live with us because he said that if Collin lived with us, Kathy would be over at the house and he didn't want to have to deal with Kathy.
Ma'am, didn't Nikki say he didn't want Kathy, he didn't want Collin to live with them because he was afraid that Collin might kill you or kill him?
No.
All right, now let's move on to the subject matter of kitchen knives or butcher knives. Do you tell the jury about the time when you noticed that there was a knife missing from your residence there in Auburndale, and you were trying to figure out who stole the knife or who took the knife?
Yes, there was a small knife with a blade like this that I bought in at the dollar store, which is now like the $1.29 store, and it had a protective cover on it, and it wasn't in the drawer with the rest of the knives and silverware.
And did you find out eventually that your grandson had taken the knife?
Yes.
And he basically told you he just needed it just in case and did not elaborate on what he was going to do with it?
He said he just needed it.
Now, at that time also, Kathy made it explicitly clear to you that she was afraid that the defendant might hurt her, correct?
Not at that time, it was later.
And there was multiple times when Kathy let you know that she was afraid for your safety and for her own safety.
Yes.
Now, you mentioned that a couple of things about the 7th and the 8th of September. You mentioned that Collin told you that he didn't have a phone with him on the 7th. Is that correct?
Yes.
Were you aware that he did have his cell phone with him and it was in his car?
So his cell phone had been turned off by his mother. She used to do that anytime she'd kick him out. She'd turn the cell phone off. In fact, it's in the records that she turned it off, and she turned it on, and she turned it off.
And you mentioned that the sliding door, that it had no lock on. Is that correct?
We had adapted the sliding door for a doggy door so Freddie could go in and out when he was staying in Auburndale on acid house. And so we did not have a locking mechanism. You could close the door, but you couldn't lock it.
And so that's how you mentioned that your grandson was able to get into your house on the 7th
Oh, plus the front door was, I don't believe in locks. I've been burglarized and the burglars got in quicker than I could find my lock. I don't lock things.
Okay. Now, your response when this was going on, when law enforcement made contact with you, was that you didn't know that Collin was a psychopathic killer, correct?
I never said that. Never.
If I may approach, please, Your Honor. And I'm going to show you page 59 of 67 of her statement on September 8th.
Let's see it before you approach.
I'm sorry?
I wanted you to see what he's
Thank you.
referring to before you approach.
And if you could just take your time and read the highlighted portion to yourself.
For one thing, I don't use words like stupid, Colin. I would never say that.
Oh, man.
He just wants you to
Oh,
read it to
okay.
yourself.
Oh, I'm sorry. I'm sorry.
That's all right. That's all right.
We may need to go sidebar real quick.
Have you finished reading it?
Yes, uh-huh.
Approach sidebar.
I'm sorry. What the just happened? So she, please Han Solo, please impeach her, because that would be the perfect ending for this. Because if he gets to impeach her right now on the stand, saying that she lied, saying that she called him a psychotic killer, this will be it. I mean, this will be it. Collin, say goodbye. Because this will be it. Because all her testimony, whatever stuff she said about Kathy, right? It will be done. It will be. And I'm yet again. I am not saying Kathy was perfect. I'm sure she had her wrongdoings. No, everyone has them, but all her testimony will be absolutely there. Because the thing is, if your daughter, right, gets pregnant at 13, you blame your husband. Where's your blame? Are you the Mother Teresa of the mothers? Because I'm sorry, but for your daughter to be pregnant at 13, something has happened. Something has happened for your daughter to get pregnant at 13. You're not going to tell me that you are perfect and you don't have anything to do with that. Because either one of the things is, either were you working all the time and you're not present, yet again, that the fault is yours, or you were there and you did not do anything. Because how did she get... Like, so, and she goes and tells that whole fault is the dad. Like, I'm sorry, but that is just no. I am absolutely no. And then now she's saying she was reading first of all, the message that she was not even supposed to be reading, right? He highlighted the one that he wanted, and she was saying, "Oh, I don't use words like that, like stupid or whatever." I was like, "Excuse me, man, just do whatever Han Solo told you to do. Don't go off to something else." But I mean, this is getting spicy. This is getting good. This is getting good, and I hope he can get it in and impeach her once and for all. Of course. Oh, did I count that objection, guys? Oh, I was so livid and so wanting to talk about this on the sidebar that I forgot. Did I count that objection? Should I put one more? Let me know. But it's just absolutely ridiculous. This lady needs a course of how to be a mother, because she doesn't know. Because that's like, she thinks that everything bad, it's Robert Wallender's fault. Everything good, it's her. That's not how motherhood works. It's both. If you were both, like, it's... Oh, it is. Okay, thank you. I don't know. I was I'm so mad at this lady that I don't even know. It is just like ridiculous whatever she's saying. I don't believe her on one thing. Oh, it's all right, Paula. So, very quickly, Han Solo, the prosecution attorney, is trying to impeach the grandma because he asked her, "Did you ever said that Colin was a psychotic killer?" And she said, "No." And Han Solo is trying to impeach. I would rewind because it was very spicy and you got I don't know how much you missed. I would rewind, like play on 1.5 or something to try to catch up, but I would. And then you can skip me talking because no one wants to hear that. But I am absolutely livid. I think you absolutely should rewind and listen to it again. And then we'll see you very, very back. We'll try not to spoil anything, but it's gonna be good. So we just waiting for the sidebar to be over. They still talking. These sidebars are taking longer and longer, guys, because the defense is definitely trying not to not to thank you, Paula, nothing to come back. So huh? No, I am not gonna say that, Nightbot. Even if you're trying to get me to say something, I don't know. So so it's just trying to wait for them to come back. Yeah, oh, that would be absolutely. I hope what me saying that toxic, or if Han Solo tried to impeach, huh? Nightbot, I don't understand you. You have to probably come down and explain because I am not understanding you. Sorry, he's upstairs and I'm downstairs doing this because it's a split level house. But yeah, oh yeah, Colin, Kathy had issues. Not gonna say that, Nightbot. Sorry, it was just yelling. Kathy had issues. Nightbot has issues. Yes, Nightbot has issues. That's for sure. Colin has issues. This Grandma Susan has issues. Robert has issues. Charles had issues. Whoever Chuck was had very big issues. This whole family has issues. Right? It's a issue family. I'm sorry. Can name them. The Griffiths are issue family, and the Wallantas too. No one is perfect, but no one deserves to be unalived like that, like Kathy was, or being unalived. Period. And then for you to come to court and talk poop about your daughter in open court to the world to hear. And then you're going to say, "Oh, we're going to do a celebration of life in the summer." Yes, because we did not get the chance to do one. So we're going to celebrate Kathy. It's like, excuse me? Like, are you not a two-edged sword face B word? What does the Bible teaches you, ma'am? Have you read your Bible lately? Like, she's like, honestly, these people um um I don't know. I don't know. I'm not understanding what Nightbot really saying toxic, because I think it's with the fumes where what he's doing is just like, now as like, I'm sorry, but she is talking absolutely nonsense about her daughter. Blame her husband for everything that is bad. And then and now saying that exactly basically your comments, okay, that Colin is an angelic force. I want him to ask. I don't know if he's already asked about the unaliving that happened, because he can ask about it. He can just not say who he was, but I'm sure she would slip up and say that. Can you imagine? She's saying that the Colin unalived the dad in open court. Defense would absolutely go for a mistrial straight away. I bet you $100 that the defense would move for a mistrial right there and then, and we would have probably a mistrial, because that is the big no-no. And this lady, she's literally saying things and going on things that is not even relevant to the question that they're asking. uh so I would not be surprised if she would go with absolutely, yeah. uh, it- oh yeah, the new husband, exactly. Okay, thank you for reminding me. So the new husband of grandma, so grandma must have remarried at some point, so he doesn't want Colin to live with them because of, he doesn't want ah Kathy or anything to create confusion, on Colin to create fights and everything, because apparently they were living in a very strict closed community that you could only have guests at certain times of the day, because you guys heard that when Colin went to grandma's house, that was not locked, by the way, because she doesn't believe in locks, because she's been burglarized too many times. She doesn't believe in locks. Okay, so she doesn't lock the house. So he goes there, and she said to him that do not go outside until she gets there, because the community would not, like, they could kick her out basically, because it's a closed community. um it's just like, I think she is, and like I'm sure, I'm sorry, but if he gets off of on this, right, and goes home, I'm sorry, but she might be next, because in self-defense he had to unalive her, because she was a horrible grandma. She did not give me the things that I wanted. I had the freedom or Starbucks or anything. I'm sure he's gonna try to offer. And it's like, um yeah, exactly. And it's like, I don't think he's gonna. Oh, definitely, absolutely, 100% toxic. I think everyone in this family is absolutely nuts, crazy, and all of them should be locked up in a mental facility to get help. Oh, and then she was trying to blame the politics and the government because of the mental health at one point. That because Kathy has mental. Why did you not try to give her mental health when she was a kid? Like, she got pregnant at 13. You couldn't have helped her. Like, where were you when she was 13 for her to get pregnant, ma'am? Like, can you tell me that, how were your rules that when she was 13 she had Colin? Oh yeah, she will always blame somebody else. It's never her. She is this angelic, like her and Colin are the angelic part of the family. They are the angels up in heaven, and not, honestly, I just don't get it. This family, I'm sorry, should all be locked up and throw away the key and move on, because it's crazy the kind of excuses that she's trying to make for her grandson. And I mean, it's like, I know it's, you love both them equally, or probably sometimes you love grandkids a little bit more, but still, it's your own kid you're throwing under the bus. So you're telling basically the court that she got what she deserved. That's basically what she's saying with her testimony, isn't it? She's basically saying in the court that she got what was coming for her. So, I mean, it's, yeah, yeah, exactly. But what did put her there, Denise, and why she? Well, probably she cannot go back when you are pregnant. I don't know how that's that. So yeah, it's, so that's the thing. It's like, fair enough. If she was in the Hope House when she got pregnant, why was she there in the first time? Something must have happened to her that caused such a trauma that she needed to go there. So let me so Google that. One second. Hope House, I'm assuming is in Florida. um oh, hang on. So Sorry, I don't know if it is the same Hope House. There's like Hope House exists to serve, equip, and empower first-time expectant moms who have chosen life for their babies. So you only go there when you're already pregnant, correct? Because that should. Well, oh yeah, there's another Hope House. There's two Hope Houses apparently. I would like a website, please. Yeah, there's another Hope House, but I don't get the description. So there's apparently more than one Hope House in Florida. I don't know. Oh, where was? I don't know if they've lived all their life in the same area. So I'm just. Well, true. Okay, probably I'll retract that part. I apologize, Denise. Thank you for correcting me. They were getting help, but for what? What was so traumatized that yeah, I get it. There was a lot. So I don't think I can like condense our research in just this short time that to give information. You probably are correct. They were trying to get her help, but for what? I want to know why she was in a Hope House. If we are here to talk about the case, why was she in a Hope House and who put her there? And then those questions then come up. Who put it there? Why was she there? And for how long was she there for as well? Because we know she was already there when she got pregnant. But then how long has she been there? How long can you stay there? So, yeah, my questions. Apparently we are back.
All right, thank you, Ryan.
Ms. Detman, we're almost done, all right?
Thank you.
You're welcome. Ms. Detman, is it a fair statement that Kathy had expressed to you that she was getting very frustrated with the fact that your grandson wouldn't do his chores, was disrespectful, and was basically just taking his mom for granted?
Yes.
And when Kathy was communicating with you on September 7th and September 8th, that was the Saturday and the Sunday, she did so by both text messages as well as phone calls, correct?
Yes, sir.
And Kathy made it clear that she wanted your grandson home by 10 a.m. on Sunday, correct?
Yes, sir.
And then when that didn't happen, when 10 a.m. came and went, she still made it clear that she wanted your grandson to come home, correct?
Yes.
And Kathy mentioned that she wanted him home. She wanted him to go get work at Domino's from like 4 or 4:30 to 8 or 8:30 on Sunday, correct?
Yes.
And your grandson was working at Domino's, correct?
Yes, he was.
And so Kathy wanted him home so he could then go to Domino's that night, correct?
Yes.
And then kind of towards the end of the communications, then Kathy told you she was going to your house to get Collin to come home, correct?
Yes.
And she told you that either he could go home with her or he could drive, basically follow her in his car, correct?
Yes.
All right. Thank you for your time today, Ms. Dedman.
I have no regret.
The witness released.
Yes, sir.
She released.
Yes, sir.
Thank you.
Thank you.
Any other witnesses or other evidence you wish to present?
No, sir. That's right.
Rest. Will there be any rebuttal, Mr. Levine?
No, Your Honor.
Ladies and gentlemen, both parties have rested their cases. The next phase would be closing arguments, followed by your instructions on the law and then deliberations. Closing arguments in these types of cases are typically not short. Also, I need to have a conference with the lawyers regarding the jury instructions, although it is up to me to decide what laws apply and how you should be instructed. They do have a right to give input. That conference could take some time. So if we did all of that in closing arguments, we would be sending you out probably mid to late afternoon. And I don't want to do that to you. So I'm going to give you an early day today. We are going to work the rest of the afternoon to get all of those strings tied up so that tomorrow morning we'll begin directly with closing arguments, and then the instructions will already be finalized, and you will be probably going to deliberations around lunchtime, I would imagine. So you're going to have an early day. Now, although you have heard all of the evidence, actually, I'm not quite sure about that. Give me just a moment. Would you approach just sidebar real quick?
Oh my days, you guys, what? Like, I think Denise, I think you are right. I think the cameraman had a fainting episode because, guys, the defense rested. What? Are you? Oh my days!
Our schedule, ladies and gentlemen.
1 second,
So
dear back.
before I dismiss you, I just need a few minutes with the lawyers outside your presence. So if you would just wait for us in the hallway for a moment.
All right, please.
Okay, before they go talk, Ay vamos. Good morning. Welcome in. Thank you very much for your support on Saturday. I didn't thank you early in the stream, but you're there. But thank you very much. I did say and thank you again for. But basically, short is defense is rested. Defense had one spicy witness this morning. The grandma, college grandma, was absolutely fantastic. Definitely worth a watch. Maybe watch on speed. The thing is, we don't know if they're gonna leave the camera up for the jury instructions. I guess we'll see. But
Would you raise your right
guys,
hand? Do you solemnly swear or affirm the
oh,
testimony
the
you're about to
quality
give
with
is the truth,
Collin
the whole truth, and nothing but the truth?
about
Yes,
fine.
All right. I did not ask you about whether or not you wanted to give testimony in this case, so I need to talk to you about that. I assume, based on your lawyer having rested, that you did not want to testify. Is that correct?
No, Your Honor.
That's not correct, or no, you did not want to testify?
I did not want to testify, Your Honor.
And have you talked about that with your lawyers today?
Yes,
Have you talked about it with them on more than one occasion?
several, yes.
And did they answer any questions you had about whether or not you should testify and address any concerns you had about doing one thing or the other?
Yes, Your Honor.
All right. And do you need any more time with them before you answer my question in a few minutes about whether this is your final decision? Do you need any more time with them?
Take a minute.
All right. So he can, Mr. Larson, if he can take them to the jury room.
47, 49.
So I think the judge forgot to do the quality with Collin about if he's gonna testify or not, but he's not, but he's just trying to cover himself in terms of never mind, Denise, don't check. I think you've already replied to me. I'm just not ignoring. I'm just but oh my days, so we could have been on verdict watch today, but the judge is gonna spare us and not to do that. So what's gonna happen now is they are gonna do the charge conference this afternoon. Now that when the jury is excused, they're gonna be working on jury instructions. I don't know if they're gonna do that with the camera on or not. We'll see. If they don't, we'll have a short day. I'll have a short evening, and I'll take advantage of my evening free with Nightbot. If not, we'll be here for all the time that is necessary. But tomorrow, you guys, I think the people that do the trials, even though it's different states, and this is just me being silly, they work in our favor because we have our new trial starting hopefully tomorrow. And now we have this trial finishing tomorrow. How perfect is this? this is just a bit like it's too perfect and too good to be true, but I'll take it.
Griffith, you've had just a few minutes, I assume as long as you
We go
wanted
back
to
again.
talk some more with your lawyers about this, correct?
Yes, Your Honor.
And did they answer any additional questions or concerns that you had?
They did, Your Honor.
You got any questions of me about your right to testify versus your right to remain silent?
No, Your Honor.
And it is your right to remain silent, and I'll be telling the jury that you're not to be concerned by that or view it as an admission of guilt. But one thing I need to make certain of is that you understand that this is your choice in this case. You understand that?
Yes, Your Honor.
There are many things your lawyers can do without your permission, things they can do that you disagree with, even things that you speak up and tell me you don't want them to do, but not this. You understand?
Yes, Your Honor.
Have they explained that to you, that no matter what they think, it's your decision?
Yes, Your Honor.
Now, they are supposed to give you some advice and counsel about what they think you should do. Are you satisfied with the advice and counsel they've given you?
I am.
And today, are you under the influence of anything, drugs, alcohol, or medicine?
No, Your Honor.
And any concerns related to competency? Have any of those arisen over the weekend, Mrs. Hornfeld?
None.
Mr. Hendry?
No, Your Honor.
And has anyone, including either of your lawyers, promised you anything or threatened you to keep you off the witness stand?
No, Your Honor.
This is your choice and your choice alone,
I know, Your Honor.
is it?
Yes.
And you do not want to testify?
I do not.
Anything else you want on the record,
No, sir.
Mr. Hendry?
No, Your Honor.
All right. Okay, we can have the jury. I find that your choice is freely, knowingly, and intelligently made, and that it's made upon the advice of competent counsel.
And Your Honor, we're not raising additional argument on judgment of acquittal, but we would maintain our previous motion.
Same rule.
So while the jury comes in, guys, don't forget to play the game. Play of verdict. You either can do on a Google Forms that's going to be in chat. You can fill it out. You might win a prize that I am working on, but there's still going to be. There's a couple questions about how long the jury is going to deliberate, how long it is everything going to be, how if it is guilty or not guilty. You have to have the verdict correct, and the deliberation is the closest. So tomorrow we'll see whoever gets the closest to the deliberation having the correct verdict wins a prize. I am probably gonna get some like stickers done for the channels with some fun stuff that we have done so far and some other stuff that is ours on our channel, but that's gonna be, if you don't want to play there, that's okay. You can still say your verdict in chat. I will check in a minute. Yeah, I'll check in a minute. Thank you. So if you don't want to play, I can still take your notice, and you can still, if you don't want to fill the form, it is okay. I can still do on the piece of paper on there. Oh, sure, you pay my pastry. That's true. Thank you very much, Kay, for keeping me right. Because so this is the pastry I baked today. Oh, it's falling apart. Hang on 1 second. I probably need to put myself a little bit bigger. 1 second. Let me try to put myself bigger. Hopefully that's not too big for you guys, but this is my pastry. It's a peach and almond pastry. It is very, very nice. I have been here literally looking at it and wanting to eat it, and just, yeah, it is very yummy. It is very good, especially when it's warm. So sorry, let me just write. So Toxic says guilty. Do you want to say, Toxic, do you want to say how long it is going to be? And then Lois already done. Oh, 2 hours. Sorry, I only see 2 hours. Lois, Susan, guilty. Oh, it is very good. Yes, the jury heard the grandma's testimony. Yes, Paula. Yeah. Susan, how long is gonna be the deliberations for you? What is your um guilty Nightbot, how long it is gonna be? So you guys can just tell your guesses. I need to just change something, and I need to do that. Yay, awesome. You guys can complete the document. I will get the answers, and then I can just compile everything. 2 hours for Susan. I just need Nightbot to tell me how long. Okay, it's guilty and 90 minutes. We'll see who wins. Obviously, I am not gonna be part, and I will put Nightbot puts long. Nightbot, you have to give me a time frame. So 2 hours guilty. Yes, you are on the list. 2 hours guilty. So it is the game is being played. So me, of course, I am not gonna be on it, obviously. Nightbot, if he gets, is gonna be the second person, because he is my other half. It's not really fair, so he says 1 hour. But if, yeah, if for example Nightbot wins, I will give it to Kay, because it's only fair. I can give him a present whenever. I actually brought him a present today, because you guys, I bought this pastry for me, and I bought some pastries for him. So he already has his present. So so he doesn't need any more. So 3 to 5 hours for but it's fine. I'll check your guys' answers later. But yeah, it is actually we're gonna be doing this verdict thing. I'll pin the verdict game if anyone wants to come in and play with us. Hi Pickles, hello, good morning. Well, you missed some spiciness. Okay. All right, sorry about that. Denise, not guilty. Ooh, 2 and 5 hours. So that's, oh yay, Paula's caught up. Awesome. Paula, how good was that? How good was that, Paula? Oh my days. I'm so happy with this. Oh, sorry. Just checking that the thing is still on. The microphone. But Pickles, we are just doing a bit of a game, because the case is basically finished. They're only gonna do closings. So we play a game on verdict. That is, we call it, you give your what you think is gonna be guilty, not guilty. And then how long you're gonna be, and then you have a chance to win something from me, from the channel. So you have pinned a message of a verdict form, but if you don't want to fill it, or if the form is not as not working, just let me know what you think in terms of if it is guilty, not guilty, or hung, and then how long they're gonna be deliberating. To be able to win, you're gonna have to get the verdict correct, the guilty or not guilty, but the deliberations is the closest to it, obviously.
All right, ladies and gentlemen, as I was saying, although you have heard all of the evidence in this case, you still have not heard the arguments of the lawyers or the instructions on the law. So remember, it's not time to think about how you might decide the case or to formulate any opinions about the merits of the case. Also remember to avoid the news, as I previously instructed you, and to avoid talking about the case with anyone or looking anything up. Now, tomorrow, you'll be receiving this case for deliberations. I want to remind you that a jury may deliberate as much or as little as it feels necessary to that particular jury to do so. But what that means is that it's possible your deliberations could go past 5 o'clock if that's what you all agree to. It could be earlier than that, but the point is, you may want to let those who would normally be expecting you after 5 o'clock, that if you're not home, that the jury has chosen to continue deliberating. So just keep that in mind. Also, if you've been bringing your lunch during jury service, you may still do that, but I want to advise you that the court will be providing you with lunch tomorrow, because I anticipate you will begin your deliberations around lunchtime. That way you won't have to separate because you won't be allowed to deliberate unless you're all together at the table in the jury room. That will facilitate your deliberations beginning as soon as possible. So I hope that you enjoy the rest of your day, and we will see you tomorrow morning at 8:30.
All right.
Okay, so while the jury is exiting very quickly, make sure that you like and subscribe the channel if you're not. So it helps a ton, the liking on the DNA. If you leave your DNA in the like button, it helps us a lot for the YouTube algorithm and so forth. But yeah, and thank you everyone for playing. I'm really excited about this. I've got all your guesses. I'll make sure that yeah. Ooh, wow, Paula, that is very warm. Actually, it is quite warm here in UK today too. I need to check how many degrees is in Fahrenheit because I have in Celsius. So bear with me 1 second. It is 49 right now, so it is actually quite nice here as well. So it's oh wow. Sorry, I will not say that it is very warm here in the UK today. So we'll see what happens if they are just taking a break, if they are um done for the day or something. I don't know, because I don't know if they're gonna carry on the conference charge on, if they are taking a break. I don't know. Did you guys hear anything? I was quite busy, like writing, make sure that I have everyone's guesses, and so yeah. Oh yeah, in 2 months you'll be much better, Lois. That is gonna be amazing. Um, oh well. Yesterday was Groundhog Day, wasn't it? So what did he say? I did not see. What was it? How much long of winter did the groundhog dog Phil? Is it Phil? Does he call? So do you guys do? Yes. Oh, so does that mean six more weeks of winter? Okay. See, I am informed about things that happen over in America, so I am just writing down very quickly the names of people that lie. So because I vamos, sorry, not 1 second, everyone, give me 1 second. Nightbot, again, Nightbot can play, but you won't. And I need to scroll up because now I know, sorry, I forgot how that, but that's fixed. I've got everything is fine, everything is perfect. Oh, I did not see that. I only saw a bit the report that was Groundhog Day, and then everything. But then I saw a very funny picture of the groundhog Phyllis, the wife of Ground. I don't know if it is. Don't quote me. Saying that it was a liar. That it's gonna be not 6 more weeks of winter. It's gonna be a lot more. But that was funny. So if you weren't here in the morning, we had a very spicy morning. It has been a very good morning for for this case. I am writing down so much stuff because I need to update our spreadsheet that we do, because we have a spreadsheet of all the cases that we're following in this channel, and we keeping track of how long they deliberate, how long is the case, and whatnot. And I need to write down that the state case was 3 days, basically the first 3 days, and that the defense case was what? Do I put 1 day? Do I put 2 hours? Because that's basically all their case was about 2 hours of a case. What do I do, guys? I need your help. I need your input, because I don't know what to do. Because I don't think I can put hours, because I'm doing the analysis on track of days. So do I put just 1 day? Yeah, defense was 2 hours. So half a day. Okay, half a day probably works. Half day will probably work with the. Oh, awesome! I was like, oh, I was like, I don't like really the warm weather because my eczema gets so much worse when the heat when if I get overheated, my eczema just starts to flare up, and I don't like that. That's why I like the winter, because in the winter I can put a lot of clothes on and then I can adjust. But in the summer, can't really do that, can I? Unless, oh no, let's not talk about it. Let's not talk about it because I don't want to get canceled already. Yes, grandma was the only witness. Defense started the case today, and so in the morning the states came in. It said he arrested. It was done over and over with this case. The defense did a JOA, a judgmental of acquittal, and it got denied by the judge. And then the defense was the time the defense put on their case. Put their case, and they called the grandma, and that was the only witness. Han Solo tried to impeach her. I don't know. She did damage his case a little bit, but I don't think it was that damaging. Nightbot, I'll talk to you later. Don't worry. I don't think it was that damaging for the prosecution. I think they still have quite of a solid case, but now everything is going to come down to the closings. Everything always, like, even though it's not evidence, but it's still going to be talking about the case and both sides, and the state is going to have always the last word. And Han Solo is going to probably do that. It's going to do the first part, and then it's going to be the last part for them. But also, Nightbot is chancing his luck today. Gotta love him. Actually, tomorrow I am gonna have to talk to Nightbot. If Nightbot would come down here, I would talk. We could talk, but because obviously we're gonna be in deliberations after lunch. That's what the judge said, and that's exactly what's gonna happen. So lunchtime for me, it's about 6 p.m. I am back at work. So I will do the first few hours of the deliberation, but then Nightbot will probably have to take over the deliberations. Yeah, I think I need to call Nightbot. Oh wait, no. I don't know. It's the sound came in and then the sound went out. But like I was saying, Nightbot might have to take the last few hours of deliberation, because my plan was that while we are on deliberations, to listen to the opening statements and whatever else happens from our new case. And I need to teach Nightbot how to do that and how to change feed and how to keep an eye on that. I mean, I can do a bit, but because I'm back at work, I can't sadly stay up too late. So I'm sure he's gonna be fine and doing that for us. So it's not gonna be a problem. Also, are we coming back? Are we not? Are we coming back? Oh, okay.
Proposed by the state. All instructions that have been given so far will go back. We will start this morning with 2.3 stipulations. I have included the exact language from the written stipulation that you handed to me that I read in court as part of that instruction. Is there any objection to that? Mr. Levine?
No, Your Honor, thank you.
Ms. Thornhill?
No objection.
All right. That takes us to 2.7, closing argument. That appears to be standard. Is there any objection?
No, sir.
3.1, introduction to final instructions is standard. Is there any objection?
No, sir.
3.2, statement of the charge is standard and accurate. Is there any objection?
No, sir.
It seems like the substantive instructions on the crimes are at the end, but they would come next. And we begin with 7.1, introduction to homicide. That is a standard instruction. It states what appear to be the appropriate lessors.
Yes, Judge, hold on, let me get to it since I didn't reorder that. Tell them. It does appear to be standard and accurate.
No objection.
No objection.
All right. 7.2, first degree premeditated murder. Appears to be the standard instruction. Is there any objection?
No, sir.
7.3, first degree felony murder. Appears to be standard. Is there any objection?
No, sir.
That takes us to 7.4. Well, after that, I would give when there were lesser included crimes or attempts. That is back up. Here, and again, it states second degree murder and manslaughter as the lessers.
Those are the category 1 lessers.
Any other lessers requested?
No, sir.
And then for kidnapping, false imprisonment.
Correct. Also a category 1 lesser.
Any other lessers requested as for kidnapping?
No, sir.
All right. All right, second degree murder appears to be the standard instruction. Is there any objection?
No, sir. There doesn't appear to be a manslaughter instruction in the packet.
I don't have it either. Let me pull it from the Florida Bar website. Give me just a moment.
No, I'm not down here.
And now we don't have audio. The audio keeps coming in and out. I don't know how it is the audio for you guys. But and sorry, I just had to change something on here. On the channel. So it's not much going on at the moment. They are working through the jury instructions. I forgot the name. So but apparently the lesser for the unaliving charge is manslaughter. There is no lesser for the kidnapping charge.
Crimes or attempts. Is there any objection to the kidnapping instruction as proposed?
No, sir.
All right. So since the state did not include 7.7 manslaughter, is the state asking to proceed on just manslaughter by act, element 2A?
Yes, sir.
Do you agree with that?
I do agree with that.
All right. So it will read to prove the crime of manslaughter. The state must prove the following 2 elements beyond a reasonable doubt. Kathy Griffith is dead. Have you been putting her middle name in?
No, Your Honor.
And then I will take out the A, the letter A. Element 2 will simply read Collin Griffith intentionally committed an act or acts that caused the death. Kathy Griffith. next paragraph, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously explained to you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. And that's it, correct, Mr. Levine?
It is, and thanks for taking care of that, Judge.
Ms. Thornhill, you agree that's
I-
all they should be instructed on?
I do agree.
Just a moment.
And the audio is gone again because I think the judge is just working something on his computer. I was gonna check something, but apparently now I have to talk, and that it is an awesome thing to do. So sorry, I just had to turn on something. Hopefully everyone can still chat and everything is still okay. I can unpin my message from earlier because I think so yeah, so tomorrow that's the plan. We're gonna be here. I think they're gonna start at exactly the same time. They're gonna go straight to closings. So I think for him to say that the closings are gonna take all morning, they might be 1 2 hours, 2 hours 1 hour each, because if it's only if they're only starting like at 10 o'clock in the morning, then I don't see
9.2 false imprisonment, which
Yeah.
appears to be standard instruction. Is there any objection?
No objection.
All right. Moving back up.
Judge, do you read excusable homicide and justifiable use of deadly force after the lessers or after introduction of homicide, or?
Well, I generally read that after all lessers,
Got it.
unless you want it someplace else.
Nope.
Mr. Levine?
I'm fine with whatever the defense requests, Your Honor.
And so that would come next. And let me pull up that construction. I had it up somewhere, I think, this morning. Right, that is 3.6F. This was proposed by the defense, but it's got the whole kitchen sink in, so we need to talk about that.
Yep.
Just a moment.
And again, the audio. Oh, really? Oh, I don't think it's gonna take that long because they're moving pretty quick. I mean, it's not that big of a case. It's only been what, 4 days, 5 days,
The
5
title
days.
should just be justifiable use of deadly force, correct?
Correct.
It is a defense. You're claiming self-defense only as to count one, correct?
The first degree murder, yes.
It is a defense to the crime of first-degree murder if the actions of Collin Griffith constitute the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Collin Griffith does not have the burden of proving that he was justified using deadly force force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. Collin Griffith was justified in using deadly force. He reasonably believed that such force was necessary to prevent imminent death or grave bodily harm to himself. Correct?
Correct.
And you are not requesting or the imminent commission of some applicable forcible.
No, because the applicable forcible felony would be aggravated battery, which indicates death or great bodily harm, so I think it's unnecessary.
All right. Is there any dispute about duty to retreat and which instruction I give on that, Mr. Levine? There's either Collin Griffith had no duty to retreat before using deadly force, or one that begins if Collin Griffith was not committing any crime other than the alleged, I assume I would say kidnapping. No. You tell me. That's not right.
I don't think he had a duty to retreat. He was in a place that he was allowed to be, in fact, was living there, so it's like it's his home.
Mr. Levine?
I don't disagree that the defendant did not have a duty to retreat. Of course, I said in the context of the defense advancing the self-defense claim.
All right, so we'll simply read Collin Griffith had no duty to retreat before using deadly force. Why is that second part here again? Oh, because he was in a dwelling. So Ms. Thornhill, that next section is similar. To the paragraph which reads, Collin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or others. But then this next section encompasses the same context, but the same law, but in the context of standard of ground. I don't think both need to be given, but is this what you're requesting, or just the simple to prevent?
I mean, I would rather have both, just in case the jury thinks that he didn't have a right to stand his ground in this house that he had a right to be in. I realize it's somewhat duplicative, but it's the standard and that's what is allowed for. It doesn't say give this or this.
Mr. Levine?
No objection.
So, I Next part we'll read. Collin Griffith was in you want dwelling or residence?
Residence is fine.
Was in a residence in which he had a right to be. He had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself.
That's correct, and B is not requested.
I don't know why sometimes they cut the audio for, because it's just like short times and then we go back again and then I have to talk.
Section is not applicable.
You're not
correct?
talking.
Or are you asking for that? The use of deadly force is justifiable if defendant reasonably believed the force was necessary. I'm sorry. Yes, to prevent great bodily harm to himself while resisting any attempt to murder him, commit a forcible felony, or commit a felony upon him, or commit a felony upon or in any dwelling in which he was present. Are you asking for any of that?
Well, and once again, Judge, it seems duplicative, but since it's not in the disjunctive, and it's entirely possible the jury could believe that Kathy was trying to murder Collin or at least commit an aggravated battery upon him, I would request it.
Mr. Levine?
No objection.
All right.
Yeah.
All right, so we'll read the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery upon him.
Yeah, can we also add aggravated assault?
I don't object to the aggravated battery. What was the context, Your Honor, again, of the aggravated assault request by the defense?
They wanted to read the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault on him.
No objection.
But the last paragraph you're not asking for.
No, C,
Yes.
correct, I'm not asking for that.
This next part about law enforcement and excessive force is not applicable. You agree?
I agree.
Now, in deciding whether Collin Griffith was justified in the use of deadly force, you must consider the circumstances at the time force was used, the danger being not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force, was necessary. Right, this next portion about presumption of fear is not applicable, correct?
I don't think it's applicable, Judge.
And nor is the next portion of those A through D paragraphs, correct?
I agree.
Nothing about a presumption of intent to commit an unlawful act, agreed.
I agree that is not applicable.
And you need to define residence, correct? But not dwelling, since we haven't chosen that.
Right, I think
Do you
residence.
agree,
is-
Mr. Levine?
No objection.
I do not need to define vehicle, correct?
Correct.
All right. And then there's this part. However, the use of deadly force is not justified if you find that Collin Griffith is attempting to committing or escaping after the commission of an applicable forcible felony. Am I getting that?
I am not.
Yes, sir.
Okay.
Or kidnapping, correct?
Yes, sir.
Is there an objection?
No.
All right. However, the use of deadly force is not justified
I don't think that.
I don't know that that applies, does it, Mr. Levine?
No objection.
All right, so that whole section comes out. All right. And then I'm assuming you want prior threats or difficulties.
Yes, please.
It's about if you find that Collin Griffith, who, because of prior threats or difficulties with Kathy Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Kathy Griffith. You may consider this fact in determining whether the actions Collin Griffith were those of a reasonable person. If you find that at the time of the alleged first degree alleged first degree murder, should it also say the lessers?
As with a previous section in the same instruction, it could say first degree murder and all included lessers.
If you find that at the time of the alleged first degree murder or any lesser included offense, Griffith knew that Kathy Griffith,
And Judge, I'm sorry to interrupt.
yes,
The state's proposed constructions uses Catherine Griffith, so
Oh.
we should probably be consistent throughout.
all
I'm
right,
sorry.
I'll make that
Yep.
change
Got it.
before I finalize it. Thank you for that. Catherine Griffith had committed an act or acts of violence. You may consider that fact in determining whether Collin Griffith reasonably believed it was necessary for him to use deadly force. All right, as to these two reputations, are you asking for one or both?
Both, please.
Mr. Levine?
No objection.
All right. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Collin Griffith, you may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. Then, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Collin Griffith and Catherine Griffith. And that is it, correct?
Yes.
Any other comments, requests, suggestions with respect to justifiable use of deadly force?
No, sir.
All right,
And one quick question, is it my understanding that all the proposed subsections of justifiable use of deadly force have come from the standard jury instruction? There's no special request by the defense?
No special requests.
everything, what was sent to me by Ms. Thornhill appeared to be directly copied from the Florida Bar website. So,
Yes, it was.
all right. Moving back up.
So then would excusable homicide follow that?
I read, are you talking about introduction of homicide?
Yeah, that there was actually an excusable homicide instruction that was provided in the packet that the state,
Where is that?
I don't remember where it is.
Homicide, the introduction to homicide portion, I'd have to scroll down to confirm, but
I didn't see that in the copy. I mean,
You're right.
excusable homicide is included in the introduction to homicide.
But it doesn't give the explanation of what the circumstances are under which it would be excusable.
It was an incomplete instruction. I have the killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident or misfortune, when doing any lawful act by lawful means with usual ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in a heat of passion, upon any sudden and sufficient provocation, or three, same thing, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Is that what you were?
Yeah, that's what I'm requesting, and maybe it just is part
think
of
what it is-
introduction to homicide, it just,
I think what it was is, because the standard instruction has the two sections, justifiable and excusable, and they're all caps in the standard instruction, and probably what happened is
just
it
second
went
page.
to a second page. But
Got
that's in there. All right. All right, after self-defense, are there any aggravator instructions that need to be given for weapons or anything like that? I didn't see any.
Your Honor, I think in the verdict form, there's special findings, and you're right, there should be an aggravator as it pertains to the knife and the weapon, but I don't believe that I remember to include it.
That would be aggravation by carrying, displaying, using, threatening to use, attempting to use a weapon. And was that charged in the indictment?
Yes, sir.
Yes. Sure.
Just to count one, I believe.
Yes.
So that is 323A.
I'm sorry?
That's 323A. Do you object to that instruction being given?
No.
All right, let's hammer that one out. But all right, so that will read it'll be aggravation of, now, Mr. Levine, I had this discussion with, he's a juvenile, so I think it is appropriate in this case. So it will be aggravation of first degree murder, second degree murder, and it does apply to manslaughter.
Yes,
Correct, because it's a level enhancement, correct, not an amendment.
Correct.
So it does not apply to first degree murder. I don't think that prosecutors take a different, there's,
As it
it's a
pertains,
capital crime, so you can't.
Right, you
really
can't
enhance the
enhance
level.
it.
and on my verdict form, if I remember correctly, I don't have a special finding as it pertains to first degree murder.
So it should be aggravation of second degree murder and or manslaughter, correct?
That's acceptable.
You agree, Ms. Thornhill?
Yes.
By carrying, displaying, using, threatening to use, or attempting to use a weapon. And then it will read, if you find that Collin Griffith committed second degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first degree murder with a weapon, or second-degree murder with a weapon or manslaughter with a weapon. Agreed?
Yes.
Yes.
I don't need to define firearm,
That is correct.
and then I'll define weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or to any other object. Do I need to do any other object?
No, I think it's,
Pretty clear.
yeah, we're
Do you
doing
agree,
the knife.
Mr. Levine?
I agree.
All right. Then the final paragraph, so I'll take out the one as well, so it will just be one sentence. Then the final paragraph, you find that Collin Griffith committed second-degree murder or manslaughter, that you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. Correct?
Yes.
Yes.
All right. Now, there is no instruction on the issue related to juveniles. That's just a verdict form issue, correct? With the findings of actually killed, intended to kill, or attempted to kill, correct?
Yes, I agree.
All right, so that will take us then to 3.7, plea of not guilty, reasonable doubt, proof. This is the new standard instruction, I believe, correct?
Ooh, that I don't know.
Well, it may not be, and I thought, because I've been giving this instruction by memory now for probably 15 years, but I never noticed until recently that first sentence of what a reasonable doubt is not. I never remembered it saying proof beyond a reasonable doubt does not mean proof beyond all doubt. I thought it just started with
A reasonable doubt
is not a mere possible doubt. So I think this is new. Any objection?
No.
All right. And I am assuming, Mr. Levine, that that is pulled from the most current version on the website.
That was my intent, Your Honor.
All right, let me look just to be doubly sure.
In my office, I wouldn't say it was necessarily pulled from the website, but pulled from our computer that is supposed to be the most up-to-date. Jury instructions originated from the website.
And it's in there. It's on the website. That does appear to be new standard language. Oh, yes, it was amended May 2024. All right. Any objection to reasonable doubt?
No.
All right, 3.9, weighing the evidence. As to the, this appears to be standard, as to the factors for consideration 1 through 5 are always given. Do we need money or preferred treatment?
I don't believe so, Judge.
Mr. Levine,
I agree.
pressure or threat?
I don't believe that's applicable here.
Mr. Levine,
I agree.
I will give inconsistent statements. Is that agreed?
Sure.
Mr. Levine, you agree?
Oh, yes, Your Honor.
There's no felony or misdemeanor conviction, correct?
Correct.
And no reputation for truthfulness, correct?
Correct.
Do you agree, Mr. Levine?
I agree.
All right, so I'll renumber inconsistent statements as number 6. All right, the rest is standard, including expert witnesses. I will remove the defendant becoming a witness,
Yes, please.
and the rest appears appropriate. Agreed?
Yes.
Yes.
Do you want me to give 3.9A defendant not testifying?
Yes, please.
giving 3.9B dependent statements?
Yes, please.
3.10, rules for deliberation appears to be standard. Is there any objection?
No objection.
Three point one, cautionary instruction is standard. Any objection?
No objection.
3.12, verdict.
I would object if I thought it would do any good to, you don't have to be unanimous on the premeditation or the felony murder. But I don't think I have.
You're making a record preservation objection?
Yes, I am making a record for preservation purposes.
Do you wish to make any argument?
Just that I think that the unanimity requirement should apply to the different theories that the state has put forth as to first-degree murder. I think that the instruction should be, your verdict must be unanimous either as to premeditation or unanimous as to felony murder.
Any response, Mr. Levine?
No, Your Honor, I would ask that you instruct the jury on the standard jury instruction.
Law, as I understand, has not changed, and that under Florida law, they do not have to be unanimous as to the type of first-degree murder, only that it be one or the other. I think this should go before the paragraph above it.
Yes, it should.
Do you agree, Mr. Williams, that the last paragraph should go above the second to last paragraph?
Wherever it's supposed to go, Your Honor.
All right, so that's where I'm going to put it, and you agree with that?
That's fine.
We'll talk about the verdict form in just a second. Single defendant, multiple counts, I'm taking out for information in the title. But that appears to be standard and includes the caveat for legally interlocking counts. Any objection?
No objection.
That takes us to legally interlocking counts. Now, if I remember correctly, the last paragraph is not standard, but it's something that has been used before. So this is sort of a special instruction, correct, Mr. Levine?
If I remember correctly, yes. I believe in these cases, maybe even Your Honor proposed it or gave the parties an option, and it seemed to make good sense and describe everything clearly and accurately. If the defense has any objection to something, I don't object to if they want something taken out. That's beyond the standard.
So Ms. Thornhill, the first two paragraphs appear to be standard and accurate. That last paragraph reads, however, the alternative crime of first-degree premeditated murder charged in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 must not affect your verdict as to the first-degree premeditated murder charged in count 1.
I think that's an accurate statement of the law. I don't have an objection to it being read, even though it's not part of the standard instruction. It might actually help them figure things out if they actually notice that one is felony murder and one is premeditated murder.
So as to the rest of that instruction, any objections?
No.
All right. And that takes us to 3.13, submitting case to jury, which is standard. Is there any objection?
No objection.
And then an instructional discharge.
No objection.
All right, are there any other, before we talk about the verdict form, any other standard or special instructions requested by the state,
No, Your Honor.
by the defense?
I'm sorry, hold on.
So I was just thinking, maybe after they're done with the jury instruction, we can do a bit of a quick case
Any
intro
other
for the
standard or
trial.
special instructions requested?
No.
All right. Let's take a look at the verdict form. Here is the verdict. All right. And so as to count one, the first choice is for first degree murder as charged in the indictment. Second choice, the defendant is guilty of second degree murder, a lesser included offense. And under that, the further findings, and then manslaughter, which does not have the further findings. So my thought is we separate the verdict form into guilt findings and then special findings separately, since it would become repetitive if after second degree murder and manslaughter, they're the same section of special findings. Does that sound fair, Mr. Levine?
It does, Your Honor, and I would ask that you add the language under manslaughter that's there for second degree murder, the special findings. It was
Display.
I didn't put it on there as an oversight.
I think that also the finding as to actually killing, well, you've only proposed that they be asked about actually killing Catherine Griffith. You don't really need any of the attempted to kill or intended to kill language.
Yeah, by operation of the facts of this case, I'm okay with it just saying actually killed.
That's fine.
Fine.
But I,
Go ahead.
because he is a juvenile, and that's what those special findings pertain to, would you put it under after the guilt findings, then do that as a further finding? That's what
Yes,
you were
it would.
indicating. Okay.
So we would basically have count one and count two. It would be count one in order, first degree murder, second degree murder, manslaughter, not guilty. And then count two, kidnapping, false imprisonment, not guilty. Then special finding question one, if you found the defendant guilty of first degree murder or second degree murder, you must answer the following question. The defendant actually killed Kathy Griffith? Yes, no. And I explained when I'm going over the verdict form that those also have to be beyond a reasonable doubt and unanimous findings. And then, so that's special finding one. Special finding two, if you found the defendant guilty of second degree murder or manslaughter, you must answer the following question. The defendant carried, displayed, etc. Yes or no?
That makes a lot of sense.
Mr. Levine?
Yes, sir.
So I'm not going to pound through that here while you're sitting in front of me. I'll just correct it
Thank
and email everything to you all this afternoon so you have it. And if you see any errors today, it's invariably as I'm reading the instructions, I see one, but I would ask that you review them, and if you see any typos or other errors, to just alert me by email so they can be changed before they're printed tomorrow morning.
Yes, sir.
Is there anything else we need to take up this afternoon?
No, Your Honor.
I don't believe so.
All right, and I told the jury they'd probably be going to deliberate around lunch. Are you anticipating all-day arguments?
No, Your Honor, I think they will be deliberating by lunch.
I agree.
All right, everybody enjoy the rest of your day. I'll see you at 8:30.
Thank you.
All right.
All right, so that is it for the trial today. But I do have other plans. So because we are gonna be starting a new trial, hang on, and now I can move myself back here. We are gonna start a new trial tomorrow, hopefully with a new case of Megan Boswell out of Tennessee. I was thinking we can do a little bit of prep. I can make you a bit of a case introduction to this case. I was just planning going to read it a news article that gives us a bit of information about the case. So this will be our thumbnail that is on the screen right now that you can see here. Oh, I am in the wrong spot. I'm covering Little Evelyn. So we'll go here. I still need to come up with a couple of bits, but this will be our thumbnail. That's gonna probably be our new format of thumbnail. So I was working on it. Hopefully you guys are okay with it and you like it. It's a little bit more, I don't know. I think it's better. I'm trying to improve on thumbnails. But we're gonna do just a very short introduction of the case, and then I think we're gonna end the case, trial, the stream here, and then we'll pick up again tomorrow at the same time. They say half 8. We'll be here about 8:15, 20 past 8 in the morning. So this on the screen is we've got on the big screen, on the computer screen, Megan Boswell, and on the little one you've got Evelyn Boswell. This is a very sad case out of Sullivan County, Tennessee, which the jury is gonna be sequestered in this trial. So this for the first time in the last 15 to 20 years out of Sullivan, Tennessee, the jury is gonna get sequestered for a trial. So the case started way back in 2019. So in December 2019, that was the last time that little Evelyn was seen by family members. 2 months after, and this we are in February 2020. Evelyn's granddad, Tommy, I believe is his name, Boswell, reported to the police. Yes, tomorrow's gonna be a good day for that to get up early. So Tommy Boswell in the February 2020 calls the police saying that he hasn't seen Evelyn for a couple of months and it is deep concerned. After a few days, police sends an Amber Alert, gets the troops ready, and he was actively searching for Evelyn. Shortly after, the police, the TBI, the Tennessee Bureau of Investigation, found the remains of Evelyn in the house of Tommy Boswell, in the family member's property. This it was in March 2020. So after that, Evelyn's the case carried on, but at that time Megan was already arrested. Megan was arrested first of all. The case is heartbreaking. I'm trying not to cry right now because I'm talking on that, but I want to cover because I want to see justice for Evelyn being served against Megan. Because Megan, in the beginning, she lied to everything and everyone, saying that the mom took the baby away out of her and that she had gone to another county with the baby. And then the authorities went there, and yeah, why the delay? We'll go into it. The whole case, so she only got charged in the beginning with the false reporting to the police about this. A few months go by, and finally Megan gets charged with the unaliving of Evelyn, because the autopsy is revealed that Evelyn died of axphia. I think axphia. I don't know how to say it. It is a very complicated word for a non-English native. So basically, she couldn't breathe where she was put asphyxiation apparent. So I'm not gonna even try to attempt to say because that would not. So after a few months after that, Megan is always denied bond. All the team was doing for this past few years was to delay the case, delay, and not bring justice. Last year, 2024, when the case was supposed to go out again on trial, Megan is yet again charged with a new charge of first degree unaliving because all this time that she was in jail was only with a second degree. And she was facing at one point the unaliving penalty against her because Tennessee still has that. I know. I'm sorry. I will have to try to how to pronounce that word because we might have used more. But afterwards, probably I'm gonna play you a video of the trial prep part of a channel WJHL that is covering this trial, and he's done a very good piece in terms of summarize the trial prep for this for this case. I did had it, but I have lost it again. Sorry, give me one moment because I lost the video that I was looking for. Why did I have to lose it? Because again, Court TV did a very good piece on this, but I had a very good video on this and I've lost it, which is great. Let me go on my history. Give me 1 second. Sorry, guys. I was doing so well, wasn't I? Did I do this Saturday? No, I did this Sunday. There, found it. Haha. We can watch this after. So like I was saying, they are local, yes. They are local to the area. That's why, and they are covering because they are the local news station that are covering this station. But absolutely gut wrenching case. I cover this kind of trials because I want justice for the person that is unalived, in this case sadly a baby. We covered the Ron Jewel trial, we covered Chloe's driver, and we'll be covering this because I know it is gut wrenching. I wish I didn't have to, but it is a way to actually get justice for the little ones that they did not have a voice when their moms or dads or family members should have been the voice. So instead of me talking about this, we can show you the video first, and then we can discuss it because like we normally do. Why am I trying to talk? I always put my hands in my feet and my feet in my hands. So let's just watch. It's a brief minute. It's 10-minute video, but gives you really good insight of the case and how she was she was not a mastermind, but she was absolutely horrible.
Murdering her 15-month-old daughter.
She didn't deserve this. No child does. And that's why we will continue to work to pursue justice in this case.
Over the next half hour, we take a look back on the Amber Alert and search for Evelyn Boswell.
This case is unlike anything I've ever been involved in.
Detailing the time Megan Boswell has spent in court in the 5 years since her arrest.
I want a fair jury. I want a jury that's going to listen to the facts and not be influenced on what they've heard.
And expert analysis on what to expect when her trial begins on Monday. This special edition of News Channel 11 at 5:30 starts right now. Good evening, and thank you for joining us for this News Channel 11 special report. Next week, the long-awaited trial of Megan Boswell for the murder of her daughter, Evelyn Boswell. Evelyn was at the center of an Amber Alert that caught the attention of Northeast Tennessee and beyond. The trial is set to begin next Monday, February 3rd, and is expected to last anywhere from 2 to 4 weeks. News Channel 11.
So as we speak, as I said, this was a report from last week. So today the jury is been selected as we speak, and they are expecting to start the deliberations, starting openings tomorrow. But we'll see. We'll keep it updated on how that goes.
Report. Real expectations from since her arrest.
I want a fair jury. I want a jury that's going to listen to the facts and not be influenced on what they've heard.
And expert analysis on what to expect when her trial begins on Monday. This special edition of News Channel 11 at 5:30 starts right now. Good evening, and thank you for joining us for this News Channel 11 special report. Next week, the long-awaited trial of Megan Boswell for the murder of her daughter, Evelyn Boswell. Evelyn was at the center of an Amber Alert that caught the attention of Northeast Tennessee and beyond. The trial is set to begin next Monday, February 3rd, and is expected to last anywhere from 2 to 4 weeks. News Channel 11 plans to have team coverage daily from the courthouse. Megan Boswell has been in the Sullivan County Jail since her arrest in 2020, making dozens of court appearances over the course of 5 years. Over the next half hour, we're going to take a close look into Evelyn's disappearance, the discovery of her body, her mother's charges, what to expect in court, and how her death changed Tennessee forever. Little is known about the victim in this case, then 15-month-old Evelyn Boswell. During the Amber Alert and search for Evelyn in 2020, I spoke with her mother, Megan Boswell, on what her daughter was like.
She's very sweet. She loves everybody.
This picture of a blonde-haired, blue-eyed toddler captured the hearts of people across the region and beyond.
She's just a really good-hearted baby in general.
Evelyn was born on November 18th, 2018, to then-teens Megan Boswell and Ethan Perry.
I love her. I know she loves me. She's only been around him a couple times because when I was in the Army.
Like most toddlers, her mother told us Evelyn loved Baby Shark and had just started walking.
She started walking probably around like 10 months. She was a preemie when she was born. She's like a smaller baby and she kind of had trouble like balancing her weight, but she finally got the hold of it. She's starting to say a lot of words.
However, watching Evelyn hit those milestones came to a halt in late 2019, the last time some of her family members saw her alive.
My granddaughter, she never did come back, and I just don't know what happened to her.
To understand this case and what to expect in court, we want to take you back to 2020, where it all started. On February 18th of that year, the Sullivan County Sheriff's Office says they received a referral from the Tennessee Department of Children's Services about a child that hadn't been seen by some family members in about 2 months. That child was Evelyn Boswell. The next day, just before 8 in the evening, the Tennessee Bureau of Investigation issued an Amber Alert for 15-month-old Evelyn.
We've had a child that's not been seen by the parents or certain family members in almost 2 months and was just reported this week. Evelyn was last seen in December. As you all know, these cases are already time sensitive, and we urge anyone with any information to come forward.
On February 21st, several rewards were announced for information that would help the investigation into the toddler's disappearance. More details were also given out about what folks should look out for in regards to the Amber Alert. Then on the 24th, Megan Boswell, Evelyn's mother, spoke with me for a News Channel 11 report.
Maybe they won't find her tonight, or maybe they don't find her tomorrow. Maybe it's weeks from now before they find her.
On the 25th, Megan Boswell was arrested after police say that she gave false reports during the course of the investigation and search for her daughter. More than a week passes as the search continues. That includes a sweep of a North Carolina pond near a property owned by a family member connected to the case, and the search of a property in Sullivan County where investigators looked into recently dug up ground there. Then, on March the 6th, the search for Evelyn Boswell ended when her remains were found on a property on Muddy Creek Road in Sullivan County, owned by Megan Boswell's father, the man who initially called DCS about her disappearance. It would be several more months after that before Megan Boswell would be charged with multiple counts of felony murder of Evelyn. So let's take a closer look into the life of the woman who now faces 20 charges linked to the case.
Legally, my first name is Megan. I go by Maggie. Does that matter?
This is video from the only interview News Channel 11 has with then 18-year-old Megan Boswell on February 24th, 2020, about a week after her daughter Evelyn was reported missing.
Bring her back. I just want her back. That's all I want. I've been so long without her, and I know a lot of people are like, oh, why didn't you report it missing earlier? Because my mom threatened me, and I just want her back. That's all I can think about, is how much I just want her back.
During the search for her daughter, there were a number of rumors circulating about Boswell, and we gave her the floor to address them. One being the multiple social media accounts she had and was active on.
I break phones a lot and I forget the password. I'm not going to lie to you. I'm really bad about remembering passwords. Now I have them all set to one, but up until that point, I just couldn't remember the password to them.
The other was about her family and their lifestyle.
Gypsies are not a cult. They've been asking people if there's like a gypsy ringleader and
I've never heard of referred to as a ringleader.
None of that.
Those who know Boswell best, like her mother and father, have declined to speak to us about her. Just 3 weeks after Evelyn had been found in 2020, her first attorney appointed to the case, Brad Sproles, said this about the now 23-year-old.
She's an intelligent young woman. We've had many discussions that she contributes, and she is thinking rationally about her situation and about this case, and she contributes and helps in her defense.
Her current attorney, Gene Scott, hasn't gotten into the ins and outs of his relationship with his client, but wants people to hold a judgment on the young mother until they see the evidence.
Once this case is tried, we'll prove her innocence. I have no doubt that girl is innocent.
Since her initial arrest back in 2020, Megan Boswell's case has come up in court dozens of times, sometimes in hearings that last less than a minute and others by video call during the COVID era. At times, her case breaks what could be considered typical. These are the watershed moments, though, of her court appearances. Starting on March 9th of 2020, the records surrounding her case are sealed by a court order and remain sealed to this day. Under that seal, there is no available information about what the documents are or what information they may contain. Then in August of 2020, months after the death of Evelyn Boswell, Megan is charged with 2 counts of felony murder. 1 count linked to aggravated child abuse and the other connected to aggravated child neglect. Back in January of 2021, prosecutors working the case explain why they won't be seeking the death penalty.
Prior decision by the Tennessee Supreme Court that says if you have an 18-year-old defendant without a record and only one aggravating factor, then it's disproportionate and it's not a valid death penalty in that case. That's what they decided.
Boswell's initial trial date was set for September of 2022, but issues with evidence processing from the Tennessee Bureau of Investigation and conflict with her first court-appointed attorney, Brad Sproles, led to the first of several trial delays. Boswell would eventually switch from Sproles to a separate public defender. That's her current attorney, Gene Scott. That was back in October of 2022. Sproles spoke with News Channel 11 at the time about leaving the case.
An attorney gets to the point where they can't be effective, it's our responsibility to bring that to the court's attention.
In June of 2024, Boswell was served with a new indictment charging her with first-degree murder. This new charge alleges that Evelyn's death was premeditated and intentional. The new count is in addition to her 2 previous felony murder charges. Questionnaires for potential jurors were finalized late last year, and jury selection for the trial is expected to begin on Monday. That's when the entire community will wait to see Boswell's fate that's hung in the balance for half a decade. Ahead in this News Channel 11 special report, real expectations from precedent-setting attorneys. I speak with experts to break down what to expect when this trial begins. That's after the break.
All right, so that was it. The first part. The second part, I never was able to find it. So she was absolutely horrendous case. It's a very sad case. Not taking any lightness out of it or not, but it is absolutely horrible. And I want to see what kind of a possible defense she puts on, because I can't see any. But again, it's just a heads up, I'm gonna be on full screen. I don't see what kind of possibility of defense that she can put on for this case, especially one that they say is gonna take several weeks. Well, it's just I don't see why is this case gonna, they say it's gonna take that long, but that is our next case. I do have, like, she has 20 charges on her. You guys, I don't know if you guys followed, but you know Leilani Simon, out of Georgia, she had about the same charges, and it was about 2 week trial. So I don't think this is gonna be that long of a trial. I think it is gonna be about a good 2 weeks. I'm expecting. So that is the case that we are next covering. It starts tomorrow. Hopefully, if they do seat a jury today, I'm gonna be stalking that like there's no end. As well, so what we might happen is in the morning we're gonna do closings, listening to closings and everything, and then in the afternoon, while they are on deliberation, we might do the openings of the new case while we are on verdict watch, and then carry on there. As soon as there's a verdict, we'll swap to Collin, watch the verdict, see when is the sentencing. If he gets guilty, I don't know, we'll see. I hope he does. And then we go full on this case. Like I said earlier, there's a high possibility that you guys stay the rest of the evening with Nightbot tomorrow, but we'll see, because I don't want to stay tomorrow. I don't want to stay too late, because on Wednesday night at 8 p.m. EST, I'm gonna be a guest on Trial TV Live show thing with the Squeegee of Justice. So you guys can pop in and support me, because I'm gonna be very nervous, and it's gonna be at 1 o'clock in the morning for me. So I'm gonna do that before I go to work. So that shall be fun. And then Thursday is gonna be an awesome long day. But that's the plan for today, for tomorrow. Watch the closings of Collin, and then hopefully watch the openings of the new case. Otherwise, we'll just watch some parole hearings. We'll talk a little bit about whatever is happening in life, and then we'll go from there. But I am gonna take advantage of this short day. You guys go have lunch, because it's lunchtime for you all. I'm gonna have my dinner. We're gonna make, me and Nightbot, we're gonna make homemade pizzas again, because we had them some yesterday and we liked so much that we're gonna have some today again, because it is healthy. Have it's homemade pizzas, so it's better than the ones we buy at supermarket. But yeah, I'm gonna take advantage of a short day, have a evening with Nightbot, and yeah, I thank you again as well. Sorry for Lois for the support earlier, and for everyone. And yeah, I'll see you tomorrow morning. Have a 20 past 8 EST. We will be in. Have a great evening, afternoon, or morning, wherever you are, and I'll see you guys in the morning. Thank you very much. I'll see you later. Bye, everyone.